slip for item number 1 to 4.
Oh.
But my lord, the AD is available today.
Sorry.
So he has requested that lordship may hear us, my lord, he will make it submission today. That's why that slip. I'm obliged.
There was an objection because Lordship, we could not prepare the case for.
Now we will make our part, my lord, today because there are citations and all, my lord, to be submitted. We place it today itself, my lord. They may keep their reply any day convenient. It will take time, my lord, from our side.
Right.
I'm obliged.
We'll complete it. You will give your reply. whenever you-
Make legal lordship.
Yeah.
Lordship, in item number 14, lordship, we have filed an affidavit, lordship. That may kindly.
When will you file it?
Lordship, I supposed to file it yesterday, lordship, but because of I could not stop the copies on time.
All right, then let it come next week. No? Why do you want the affidavit today?
Lordship, I am sorry, lordship. I am sorry, lordship. I am
Let it
sorry,
be next week.
lordship.
Item 14 be listed next week on a date to be fixed by the
Lordship,
registrar.
I have not informed the advocate of the petitioner. I will inform them.
You inform and come.
Lordship.
My lord, I beg to make a mention for listing of an admission item. The matter was last heard in the month of February, which was scheduled to be listed after 2 weeks, pertaining to fixation, my lord, of
Yes.
salary and allowance.
25th,
25th of May, my lord.
26th.
26th. I'm grateful, my lord.
Yes.
I have also similar here, my lord. Matter was listed on, my lord, in last listed in January, my lord.
25th, 26th.
26th. Obligement.
With the consent of the respondent, affidavit, item number 51, is a hearing matter, your lordship. This matter may be heard on 22nd of this month, your lordship.
Why?
Because the consent was given by the affidavit.
So you don't get to fix the dates. You fix the date as per the calendar of the court. It's listed today. 51 be adjourned to be listed after 3 weeks. Yes.
May you please, your lordship? Lordship, I beg to mention for listing one writ petition. It was listed yesterday in item number 58, but the respondents had mentioned the matter for adjournment without taking our consent, lordship. There is some urgency in the matter. Kindly take the matter
26th May,
next week, maybe on Wednesday next
Wednesday.
Wednesday,
Wednesday.
21st, lordship.
All right, 21st.
So
But you have to now inform the other side. Have you informed the other side?
I will inform now.
Huh?
Not
Then your complaint is that the other side mentioned without informing you. Now you are making the same mistake. You should have informed them.
I will inform.
Let's see, let's go back to for listing of. For listing for admission, this is the class listed on 24/2.
28th May. Yes.
Wait, please, your lordship. I beg to mention item number 50, lordship. Lordship, today there is a difficulty, lordship.
5
50, 50.
50.
Lordship, a date may be fixed. Any date may be fixed for hearing, lordship.
It is already for hearing. Why do you want to make a mention?
There is some difficulty, lordship.
Then don't fix a date. You are for the petitioner.
Yes, lordship.
50 at the request of the counsel for the petitioner stands deferred to be listed after 4 weeks. Yes.
Complex.
Wait, the lordship, I will hold it hands at facing my one writ petition is pending, my lord. Interim order is there regarding appointment in the APS. I will be passing my age bar. Can it be taken up tomorrow, my lord?
Tomorrow?
My lord, at the last moment, if it is at least some date will be fixed.
No,
my
no,
lord.
no. When was it last listed?
It was listed long time back, my lord.
Not tomorrow. It will be on 20th or 28th. Whatever date suits you.
That will be my lord, Monday or then.
When are you crossing your age
My
bar?
lord, within this month, I will be passing.
Within this month. All right, then 26th. We'll have it on May. 26th.
May I please, your lordship? I beg for listing of two writ petition. Lordship, it was not listed as per the previous order.
28th
28.
May.
Should be a similar pair, my lord.
28th.
May it please, lordship. With consent of other side, I beg to mention item number 44, lordship. Lordship, next
44.
44, lordship. Next week, any date,
You are for the petitioner.
lordship.
44 at the request of counsel for the petitioner stands deferred to be listed after 4 weeks.
Obliged.
May it please, your lordship. Lordship, my learned friend just now mentioned about item 14.
Item
For the,
I'm for the petitioner.
48.
One four.
1-4.
1-4.
Lordship, we also want to file an affidavit in reply to the
Item 14 at the request of the council. A joint request stands deferred to be listed after 3 weeks.
Lordship, date may be fixed. Kindly a date may be fixed.
You file your reply first, then make a mention.
Obliged.
The affidavit stated to be filed by the respondent,
Number 7.
number 7, be connected to the case record by the registrar.
Obliged.
Obliged.
May it please your lordship, I beg to mention for listing lordship, WPC 7, matter relates to pensionary benefit lordship. Next week, any date lordship.
28.
Obliged lordship.
May I please your lordship, I beg to mention for listing a writ petition for admission on Wednesday, matter pertaining to termination of service.
Not Wednesday, 26th.
Right.
May I please your lordship, I want to mention regarding listing of 9 petition lordship, out of which 8 are series matter. In those series matter, lordship, writ appeals were already disposed of. In those series matters, connected writ appeal were already disposed of. So I want to mention regarding listing of the previous pending writ petitions.
What are the subject matter?
It's regarding LGB matter, lordship, the
Regarding
LGB matter where the petitioners didn't get their salary.
what is LGB?
Lokpriya Gopinath Bordoloi Hospital,
All right,
Mental Hospital, Tejpur.
26th.
And one matter is lordship for withdrawal, lordship.
Withdrawal tomorrow. Yes.
Yes.
May it please the lordship. Lordship, the learned advocate generally reviewing this matter. He's on next in court number 1, lordship.
Just made a mention that he is making the argument.
Yes, lordship, but lordship, in court number 1, lordship, he'll be here shortly, lordship.
Or we defer it, you fix a date and
On 28th, Lord.
Lordship, there's emergency on our part, lordship.
for urgency, then you should appear
Lordship,
here.
he'll be
It's a
here
part of
shortly.
matter.
Yes, lordship. Lordship, he'll be here shortly, lordship.
So we can't wait for this. No? Once we start off with some hearing, we will not be able to accommodate him.
Lordship, he'll be here.
We are just passing it over for the time being. If he comes, we'll see. Yeah.
May it please your lordship, my lord may peruse the order dated 5/5/25.
Yes.
They have to bring some instructions.
My lord, instruction is still awaited. We have, my lord will issue notice, my lord. That will become.
Third, as a counsel to the parties, we shall notice the number 4 week. Mr. R. Thor.
My lord.
The city guardian advocate. Appears on behalf of
Respond now, my lord. 2 and 3, my lord.
2 and 3.
Others are, my lord, 4, 5, and 6 is private respondent. And 1 is, my lord, GAD.
Where is GAD counsel?
My lord, GAD, I don't know whether their name is shown in the cause list, my lord. GAD name is shown.
Don't blame it on the registry every time.
My lord, Mr. Fukan.
Nonsense.
A. Fukan, my lord,
Mr.
if you have
R.
to GAD.
Thor appears on behalf of respondent 2 and 3. 2 and 3.
2 and 3, my lord.
You are appearing for 2 and 3.
My lord.
Notices of waived extra copies be furnished. Within the period of
Each
1 week
office
from
daily.
today. Steps on respondents number 4 to 9 be taken by registered post 80 as well as usual court in 1 week. It is submitted at the bar that respondent 1 is represented by standing counsel. Petitioner is permitted to complete steps by serving extra copies on standing counsel for respondent number 1. Meanwhile, the respondents may complete their instructions and file necessary evidence. Matter be listed again on Fifth of June. 6th of June. 6th of June. Interim order passed earlier will continue till the next date fixed.
My lord, extra copy to this matter.
Extra copies
By Monday, we'll do all the steps.
within a period of 1 week from now.
Daily need for admission, I think 5.
Yes,
My lord,
reply not filed.
my lord, will file affidavit in this matter.
your statement is recorded that you know, you want the hearing to be conducted without filing affidavit. As per the last order. Yes. Ready for admission hearing?
No,
Then we'll dismiss it. Why keep it pending?
Lordship, my senior is suffering from back pain. Mr.
Back pain.
S. Nath, yes. Kindly grant 2 weeks.
2 weeks. Yes, Mr. Dor.
My lord,
Who is your senior?
Mr. S. Nath. S. Nath.
yes, oh,
Yes. Matter be deferred at the request made on the counsel for the petitioner as it is submitted. The counsel is suffering is indisposed. It's after 2 weeks. Mr. R. Dor for the petitioner, for the respondent, PWD.
item 629.
Please, the lordship. My lord, before I proceed, my lord, on 30/04/2025, my lord, a direction was given by the honorable court to produce the record by the state level recruitment commission pertaining to the marks secured by the petitioner in the recruitment process vis-a-vis, my lord, the marks obtained
What
by.
is your grievance?
My lord, my basic grievance is that we are aspiring candidates belonging to, my lord, scheduled caste and other categories in all these petitions. And we have participated in the recruitment process for grade 3, my lord, post, my lord. We have successfully qualified the first stage and the second stage. However, as per the governing rules, my lord, they are mandated to give the marks secured by the candidates in the examination, how much we have secured. Number one grievance, they have not given us the total marks, what we have secured. Number two, my lord, as per the rules again, like the last candidate who was selected for the respective category, they have also not revealed how much was the mark secured by the last selected candidate.
These
My lord.
These submissions that you're making,
Yes, my lord.
that they are required to reveal, is it mandated by some
Yes, my lord.
rules?
Yes, my lord. The
Whi-
rules,
Which rules?
my lord, there is a specific act which has been, my lord, constituted, that is called Assam Direct Recruitment Rules, my lord, of 2021 and 2022. My lord. I have the copy of the rules. I can, my lord, if I may.
Is it not available here?
My lord, in the file, my lord, I have given the copies of the rules, my lord. In item number 8, my lord, if your lordship may kindly take up item number 8, I have given a copy of those rules, my lord. Again, I can produce some copy, my lord.
Yes.
On the last occasion, Lordship, the marks obtained by the petitioner was given, submitted before the honorable court in a steel cover. But on opening of the steel cover, Lordship, found that the last selected candidate marks were not there. Again, the record was resealed, Lordship, and returned back to me. And court directed to produce the marks of the last selected candidate of the reservation category and the EWS category, Lordship. And the commission has asked me to pray for the short time. They are compiling the last person selected mark, which will be produced in a seal cover, Lordship.
How much time?
Lordship, weeks or 10 days time, Lordship.
Yes.
My lord, of course, those rules will, my lord, those records would be necessary to find out the position, my lord.
In
Lordship will
terms
take it
of,
up next
in
Friday.
terms of the earlier order dated 34, 2025, the Standing Council, SLRC. State level recruitment
Commission.
commission was asked to produce the relevant reports in seal cover. Mr. Borua, Mr. Chaudhary submits that although these reports have been furnished by the APSC in seal cover, however, on verification, it is found that the certain particulars which would be necessary for adjudication of this matter, which may be necessary for adjudication of the matter, are not a part of the reports which are furnished in seal cover. And the same has accordingly been sought for. He therefore submits that on instructions that further week's time be granted to call for the complete reports and be placed before the court in seal cover.
Madam,
It's after 1 week.
may I pay for any convenient date, madam?
26.
Madam, I'm highly obliged.
Me.
Obliged.
It's on 26.
My similar orders would follow, my lord, in all cases.
This is 6, 7, 8, 9.
6, 7, 8, 9. Obliged.
Yes.
We have received otherwise the Paras comment, but otherwise the petitioner is right now 51 years old and he is seeking compassionate appointment in this case.
Where is the petitioner? None appears for petitioner on poll. Mr. D. Bora, the government advocate, appeared for that spot. Let to be listed again.
So the legislator would like to file affidavit, we received the instruction, Manu. But the time will be required, what?
Mr. A.R. Govilder, the petitioner. Mr. D. Goswami, and at CPC. CPC has received these instructions and like to file affidavit. For 3 weeks,
Manu.
3 weeks time. This stuff 3 weeks.
Earlier.
Obliged.
Directed to file additional affidavit, my lord. They have already sent the affidavit, my lord. In 2-3 days, I'll going to file the additional affidavit, my lord. With signature, they have already
MS
informed me.
A. Gayan, at CPC. You had assured the court that to file it within 2 weeks.
With the file, but they have already sent, my lord, 1 week, my lord.
1 week, 2 weeks, but you are given a assurance.
Yes, my lord. No, yes, but that time, my lord, that has not, they didn't send the copy of the signed copy, my lord. But today, they informed me that they have already sent, my mother, they have already notarized also from Tilong.
When are you likely to file it?
And my lord, in next week, my lord. Me. In
21st. 21st. You file it by 21st.
Yes, my lord, 21st.
Matter be listed on 21st, enabling the learned CGC, MSA Gayan, to file the additional affidavit that was submitted before the court, as is reflected in the order dated 23/4/2025. Mr.
Embedia.
Embedia appears for the petitioner. It is expected that the affidavit, additional affidavit, be filed
Yes, my lord.
by the next date fix, which is 21st of May.
Yes. Must
Please
oblige.
report.
Here in this matter, records were called for. They were pleading the complaint. Records have not yet been received. The matter otherwise relates to withholding of one increment, the punishment which was imposed upon the petitioner. Some time may be granted to, because to get the record.
What is the ground for challenge?
There is several grounds.
First, there is no charge is indefinite, not definite charge. 4, 5 grounds.
You
are
filed
there.
appeal also, departmental appeal.
Yes, my lord. That was not disposed of, my lord.
Appeal is pending,
Appeal is still pending. It
still
is
pending.
2018 matter.
Then we direct the authorities to dispose of your appeal, considering all your.
It is 2018
No,
matter.
but you have filed an appeal.
We have filed appeal, my lord. Lordship may kindly see the appeal.
What is the status of the appeal, Mr. Bora?
Your Lordship, that is not reflected. in
Appeal
the-
space 50, my lord.
That is not reflected in the counter affidavit, Your Lordship.
Upon an
In your
indefinite,
counter affidavit, you have filed your counter affidavit?
Yes, Your Lordship.
they have filed a counter affidavit. It is ready for hearing. We have also filed a reply. Only thing is record is not coming.
We are asking you, when you file an appeal, the authority should be asked to dispose it of.
My lord, usually it should be disposed of within 3 months, my lord.
Your reply in para 11 says it is matter of record. Para 11 is where there is a reference that the appeal has been filed. We'll dispose of the matter, Mr. Bhattacharjee, with a direction to pass orders on the appeal.
My lord, my only concern is if they allow my appeal, there is no problem. If they reject my appeal, I have to come again to this honorable.
All right, but you have filed an
If
appeal.
the matter is adjudicated, it is ready for adjudication.
It is ready for adjudication, but the fact is you have prepared an appeal before the authority.
My lord,
There is no-
according to statute, it has to be disposed of with 3 months. After expiry of the 3 months, we have prepared a writ petition before this honorable court. And from 2018, it is pending before this court. And within this, during the pendency of this writ petition,
What
they
are
have
your-
not taken any endeavor to
What are
dispose
your
of that.
grounds? What are your grounds?
My grounds, I am showing my. Charge is, number one, charge is not definite, my lord. It's a indefinite charges. And the rule 9 is a mandatory one, my lord. His charge is not definite.
Different view. Service manual.
Rule 9(2), my lord. I have. Let me kindly see the charge first.
Yeah.
It is on page 20, my lord. He is an APS officer, my lord. While he was posted at Gosaigaon as an SDPO, some riot has been broke out there, my lord. During his posting at that time, the charge is while you were posted as sub-divisional police officer Gosaigaon under Kokrajhar district, since the breakout of the communal violence in Kokrajhar district, you are found evasive and untraceable at the time of need and neglecting your duties as DPO of the sensitive Gosaigaon subdivision. Your unauthorized absence from duty and lack of supervision in such volatile situation caused serious breach of peace in the subdivision. Besides the fallout of the incidents that led to widespread communal conflagration from one village to another, Gosaigaon subdivision, and law and order of the subdivision went beyond control, the people went at large-scale communal rampage, indulging violence, burning, looting, and many innocent people got injured due to attacks and counter-attacks. You fail in containing the law and order situation and securing the life and property of the public at Gosaigaon. Your cowardliness in blatant violation of the spirit and the letter under the provisions of the Assam 115 of the Assam Police Manual Part 3 Rule 98 of some state police, you are serious less willful daily redirection tantamount to gross negligence. Here no specific date is mentioned on which date he was not present in his duty. 2 minor, your unauthorized absence from duty and lack of supervision in such volatile situation cause serious breach of peace in the subdivision. Date, time, period, nothing is there, my lord. Lordship may kindly see the statement of allegation also. There is also nothing when he was absent, in which date and which hour.
So what is your reply?
Their reply, my reply for the, in the WS, my lord, it is
Yeah.
WS at 24 page, my lord. 4, my lord. On the other hand, on the basis of the aforesaid functionary report of the Superintendent of Police Kokrajhar, the Additional Director General of his has been pleased to add still more vagueness by addition new adjective detrimental to the career of a young budding officer without any substantiation from the side, my lord. I have denied all the charges and I have also specifically stated that charges are vague in nature and it cannot be proved, my lord. Lordship may see charge 1. There are 6, my lord. As page 25. Communal violence started in Jaipur near Kokrajhar town sometime in 19 July 2012. As soon as I came to know the violence and conscious and a prudent police officer, I prepared myself fully and endured myself that the 2 mobile phones, numbering auto and auto, personally subscribed to me, remain alert 24 hours besides the official VHF chat provided to me with complete alertness as to the usefulness as and when situation could be demanded. Both my mobile phones number 12, well known to the officers, subordinate to me as well as to my superior officer in the district. I have 2 mobile phones with me at the time of violence. I have to run here and there, my lord. I have 2 mobile phones. I have a wireless set. So,
These must be recorded in some place that you are on duty at such and such time. There must be a logbook.
my lord,
You're the SDPO.
my lord,
At that relevant point in time, you're the SDPO.
yes, my lord.
So you will have people under your command.
But that part has not been considered, my lord, by the inquiry, my lord.
No, but in your reply, where have you stated that?
Yes, my lord. I have bodyguards, my lord.
But who is allotted what duty at what time must be reflected somewhere. The arms and ammunition taken from the armory. Who has
My
received
lord,
all
that is not the charge, my lord.
No. The charge is that you are untraceable.
Untraceable, not the whole period, my lord.
Whatever it may
On
be.
a
but your
certain
reply-
date,
your
certain
reply-
hours, my lord.
Your reply has to. Your reply must show
I may
that
be
you are not
located. I may be located in some interior places, my lord.
No, but
I may be
that
contacted,
is
my
what
lord.
we are
That
asking
should
you.
be specifically.
No, that is what we are asking you. That as an SDPO, can you just go to any interior places just like that without there
No,
being any logbook?
I have armed guards with me, my lord.
Right then. Yes.
That is not the charge, my lord. Charge has to be specific on when and where, which date, on which hour I was absent. That part is not there, my lord. Number 1. Number two, I was not allowed to cross-examine in the defense, prosecution witness, my lord. Number two. Number three, defense witness not allowed and not considered by the IO.
So therefore, we were thinking that since the appeal is pending,
My-
all these grounds you have already taken before the appellate authority.
My,
We wanted to find out what is the status of the appeal. If not, we direct the appellate authority to consider and
let
dispose
them,
of.
Lord the Chief fix a date and let them give
From
some time to
2018
dispose
that
of the
it has been
appeal, my lord.
made.
Let the petition become
Yes.
pending, my lord.
Worship, I'll have
Who is the appellate authority?
Your Worship, he has filed
It
the
is the governor, my lord.
governor, but
Is a ACS officer, my lord, APS officer, my lord. It will lie to the
He is
governor.
an APS.
APS officer. 2004 batch APS officer. Lordship may do one thing, my lord. Let them give some time to dispose of the appeal, and the writ petition may keep pending for that
again,
period.
he has to challenge the appeal order. Let's suppose it goes again.
That is the problem.
But some time may be granted to the appellate authority to dispose of the appeal pending. Liberty may be granted to him to approach the court.
It will multiply the proceeding. Otherwise, it will, at that moment, if it is done, there is no problem. It is after 6-7 years, my lord.
Otherwise, your lordship had earlier directed us on 25/5/2022 to get the status of the appeal, and we had actually written to the authorities to get the status of the appeal, but till date we have not received any instruction as to the status of the appeal. Even the affidavit also silent. That,
What is the punishment imposed?
My lord.
What is the punishment imposed?
punishment
Impugn order is at page, my lord.
reduction
49, my lord. 49.
withholding of one
49
increment.
last paragraph, my lord. The governor is therefore pleased to withholding one increment in cumulative effect from the next increment due to the Anantak B. It is an SDPO Gusai Nazir Chiptagar and Department proceeding done up against Anantak B and thus finally disposed of by cheating the period of suspension with effect for as on duty. Only one increment with cumulative effect for 1 year. my lord. It's a small punishment, my lord.
It's a minor punishment.
Minor.
Did you get the records? When are the records available?
Your lordship, we've written to the Home Department. Till date we have not. Let me get 2 weeks time maybe granted. Your lordship, I'll get the records.
Mr. D.N. Bhattacharya for the D. Bora, Learned Government Advocate, appears for the respondent. The petitioner is before this court, being to challenge the. You are challenging the inquiry proceeding also.
I am challenging the inquiry report and the impugn order of punishment.
According to challenge, the inquiry report dated 11/4. The 17. As well as the order dated 23/3/2017, whereby punishment has been imposed. It is submitted that an appeal filed before the competent authority against the punishment imposed is also pending disposal. So, Mr. Bora, on the other hand, submits that the counter affidavit has been filed. Pleadings are complete, the matter can be taken up for hearing. So, he however submits that the relevant records of the proceeding are not available with him. He be permitted to take further time to bring the records. And accordingly, Mr. Bora is permitted with time to bring the records in the meeting relating to the inquiry instituted against the government advocate will also apprise the court as to the status of any orders if passed in the appeal stated to be pending against filed by the petitioner. It's after 2 weeks on 5th of June.
24th June.
5th June.
June.
5th of June.
Obliged.
Item 15. 19
Lordship notices, but order dated 24/4/2025, APSC was directed to produce the answers to this matter. They were there a few minutes back.
Where is APSC?
Lordship, my senior is in legs, Lordship. Can it be taken up after some time?
Who is your senior?
PPD, PP Datta, the standing counsel for APSC.
For some time.
After obliged, madam.
Would you let me go to the one here? Lordship is here.
Yes.
Sorry, Lordship, I apologize. Lordship, on last occasion, Lordship, I was directed to bring that effective of the candidate in respect of finance account officer, Lordship, financial rules and account.
What is your grievance here?
Lordship, the marks secured by me was not satisfactory. So I made a prayer because I got first class in the financial rules and accounts subject, your Lordship. And the cutoff date was, cutoff marks was 252, whereas my our petitioner is secured 243. Yeah.
How many petitioners? Only one.
One.
Only one.
For what purposes these answer script were called for?
Lordship,
Because Lordship, the result declared by the APSC was not according to my, whatever I have performed in the examination, my lord. So for my satisfaction and because there are orders of this honorable court also, my lord, to that regard. So Lordship, this honorable court directed since the answer scripts are available before the APSC, let it be produced before the honorable court. Lordship, if your Lordship permits my, with due permission for registry, I have called my client, your Lordship is inside the court.
So I don't know if this is permissible under the rules. Is it
Lordship,
permissible under
I
the
brought it
rules?
only for the perusal of the court.
And your Lordship may
Satisfied.
kindly have a
No,
look.
I'm not the examiner. Why should I peruse somebody's answer script?
Only the tabulation and whether marks were
That you
awarded.
can see and verify.
Yes,
Why you
in
trusting
presence
the
of
court?
my client, my lord.
You are competent. You're the client's representative.
Lordship
What cannot be permitted directly should it be permitted
may
indirectly.
not,
So you examine it.
my,
We'll polish up after a while.
Very first page may not be disclosed, Lordship. The first page of the entire script may not be.
What are you doing by keeping it under wraps? You have
No.
already declared
If
the
the first
results.
page is, Lordship, disclosed, the name of the examiner and the evaluator would be revealed.
Oh,
It
that
will
you
be
covered it.
endangered.
That you
Yes.
cover
will
it.
not see.
It will be endangered today.
My
That you cover it. From what I can see, they merely put signatures, then it is not discernible as to who is the.
I have also not seen Lordship.
So you can cover it and show it to them if you want. You cover that examining that part, and both of you sit and examine.
My lord, after some time, no?
Yes, after
My-
some. But not in the presence of your client.
No,
Be here in the court.
my,
Yes.
But on the merit, Lordship, I have some submission.
But let it be examined.
I think the
Lordship, my senior Mr. Nayak is on the court one. It's not that much.
Every matter, somebody is on legs in some court. This is also a court. What to do now? Mr. Goswami has completed his argument. Yes. Do it. We'll keep it aside for some time. Then all right.
After some time.
The least you can do is to go through the files and address the court
Yes.
instead of making a submission after some time, passed over. And then you are making mentions in every matter that you want to fix date. For what purpose? For seeking adjournment. Yes.
I received the original file, my lord.
On the last day, the file was
Is that punishment posting?
punishment posting. Lord. They have filed two sets of affidavit in opposition. One by respondent number 4. He has asserted that it is a punishment transfer. Now, after 1 year, the respondent number 2.
No, the same person has filed it in
Yeah.
a different capacity.
Both have already stated that it is a punishment transfer. Subsequently, they have filed another clarification affidavit that it is not a punishment transfer, and due to some mistake, it was stated that way. So,
May I, before submitting, my lord, may I just saying that what I have found, my lord. After going through the original records, my lord, I have found, my lord, that in the district, my lord, the whole district, there are numbers of complaints I have found against almost all the, my lord, the president, the members of GP, the General Public Act, my lord, president and ward members, my lord, they have complained against almost all the employees. Therefore, that was placed before the deputy commissioner, and deputy commissioner, my lord, cannot punish them, my lord, because the deputy commissioner is not the authority. The commissioner is the authority, my lord. Therefore, my lord, what happened in the whole district, they have supported the employees, my lord, as per this record, my lord. I'm just submitting, my lord.
but Lordship, my post is purely personal. It is
All the posters were personal, my lord.
And the government has empowered my lord deputy commissioner to reshuffle within his district, my lord. In my affidavit, I have annexed that, my lord.
Where is the relevant?
My lord,
page?
these are the official notes, my lord. In the first
In
page,
respect of the writ petitioner, find it out. and
my lord,
first.
in the writ petitioner, there are no specific order against, it shows that some punishment received, my lord. As routine, my lord,
Why have you transferred these persons, even if it is by way of a routine transfer?
my lord,
There must be some indication that these are the posts which require routine transfer.
My
Where is
lord,
it indicated?
as per the note, my lord, I have
You
seen.
show us the note, this note pertains to something else.
In the below, my lord, in the first page, the note of the deputy commissioner, DPC is there.
Then what happened? It was put up. Then what happened?
Thereafter, my lord, the order was passed, my impure order was passed, my lord. And thereafter, all except petitioner, others have joined their post, my lord.
But merely because there's a complaint petition, you release them and transfer them
My lord,
without
not
verification whether these complaints are correct, incorrect.
that deputy commissioner cannot, my lord, because the competent authority is the commissioner, my lord.
No, but if there is a complaint there, if there is a complaint in the new place of posting, what happens? You again transfer
My
them
lord,
somewhere else.
not again only against the petitioner, my lord. In the whole district, lots of complaints they have received. Therefore, without going through the complaints, my lord, they have reshuffled the employees, my lord.
Where is it written? From which office note can you say that it is reshuffled? Which office note you show us?
I'll help.
Don't wanna be paid for anything.
My lord, may I read the office notes, my lord? First, CEO, my lord. Page number 1 to 17 may kindly be seen. Complaint petitions received from concerned BDOs, presidents, and ward members, GPs, general public, etc. Against secretaries, GPC, GRS, AE, casual employees. It includes the petitioner also. Put up the petitions for favor of your kind perusal and order of if authority pleases. And order if authority pleases. Thereafter, my lord, it was placed before DPC, my lord. And DPC have noted, my lord, note above may kindly be seen. This is regarding transfer and posting of secretary
And
and contractual staffs under all blocks. Put up for your kind perusal and submitted. And thereafter, my lord, that order was placed, my lord, issued, my lord. And thereafter, my lord, CEO noted this, that as per direction, a letter may be issued to the all BDOs for releases of PRI employees by today and direct all the employees per order to join at their respective new places of posting on 17/6/2022.
PRI? PRI?
My lord,
What is PRI?
PRI means, my lord, these are The Gaon Panchayats, my lord.
PRI stands for what?
PRI means, my lord, sorry, my lord. Panchayati Raj institutions, my lord. No, it's includes all the three panchayat systems, my lord. Gaon Panchayat, Anjalik Panchayat, and District Panchayat. Therefore, no specific punishment is given, my lord. After receiving all the complaints, my lord, he just reshuffled, my lord. And in my affidavit, I have annexed one document also. Those complaints were forwarded to the commissioner, my lord. Because commissioner is the appropriate authority to punish him or do anything, my lord.
What has happened after that?
Thereafter, my lord, all others have joined, my lord. The petitioners filed this writ petition,
Oh, but after forwarding the complaint,
my lord.
was any
That is pending before commissioner, my lord, not before the district.
Lordship, yes. I have filed a petition before the Secretary Gaon Panchayat to know whether any complaint was received by the concerned department against me. And that is the note of the Secretary of the Gaon Panchayat, Lordship. This may kindly be seen. No such complaint was received.
is it a part of the pleading?
This is no.
Is it a part of the pleading? Where is the impugned order? Where is the order of transfer?
Order, this is annexed to Lordship, transfer order, page 17 and 18. For other employees, they are all regular. But in my case, it is recorded that I am casual. Except me, all are regular employees. I am a casual. And because my post is purely personnel.
Where is it shown that office is
Serial number 15. Serial number 15.
এইটো 23 আৰু আমাৰ সেইটো 21 এইটোৰ পৰা এইটো হৈছে
Are you relying on any authority to say that temporary casual employees cannot be transferred?
Because the terms are mentioned in my appointment letter. I don't know whether for other employees it is mentioned or not.
Where is the appointment order?
Page number 13, 14, and 15. At page, annex 1, at page 15. In the last part, the terms are mentioned that I'll continue till I declare. The moment
And who is transferred in your place?
সেইটো নাই এইটো কথা না না দিদি অডিট এই যে তোমাক কৰি দিয়া
Who has been transferred in your place? No one.
no.
Okay, we'll pass orders in the second half. You give the records.
Yes, yes.
You can take this back. At the end of the list, we'll pass the order. না, নহয়, আমি ক'লো আপোনাক। একো মাত নকৰে। Mr. Thoike, you are appearing in item 19.
In this series, Lordship, I have to appear because there is a challenge to a particular office memorandum of 21st May 2022. Personnel department has already filed an affidavit, but the most crucial aspect has not been addressed. So I would like to pray for this honorable court to file an additional affidavit on the basis of the records.
This is that
Disability, whether we can re-verify it or not.
disability.
Disability.
Whether in view of the disability card,
Yes.
further assessment
Re-verification.
is permissible or not.
Yes.
All right.
There's a large scale number of anomalies, Lordship. It has been found out. That's why we have to do it. And the other persons who are actually deserving, they are raising complaints.
How much time do you require?
2 weeks time, Lord.
Yes, Mr. Accountant.
But my lord, the apex court already held.
No.
My
He has asked for some time to file the affidavit.
My
Mr. Devajit Saikia, Senior Counsel, Advocate General Assam, has entered appearance in these matters. Stop Mr. P. Ugoi, learned additional AG for the state submit that additional affidavit is required to be filed in the matter.
Additional affidavit.
Bring on record some vital facts which would be necessary for effective passing an effective order in this matter. So he has prayed, he prays for 2 weeks' time. Mr. S. K. Roy on the other hand does not object to the prayer made. Accordingly, matters stands deferred to be listed after 2 weeks. We can have it on 2nd of June.
Could it be
3rd of June.
the 3rd of June, Lordship? There is some issues. Could it be on Lordship 5th of June?
5th of June, all right. 5th of June. It's on 5th of June, by which day the additional affidavit will be filed.
my lord, I have filed an additional affidavit bringing the OM which was issued by the in item my lord 20 in item 2021, my lord. My lord, I let them file the affidavit in that case, my lord, because all are documented there.
It is their choice where they want to file. Why should we indicate? Why should we indicate that?
I'll your place.
Yes.
Made picture, Lordship. The other day, Lordship, I was placing Lordship judgment in which the Lordship was pleased to direct the department to have a fresh look. That judgment I have completely read out the other day. The order dated, judgment dated 24th November 2023 at page 94. And on the basis of this judgment, Lordship indicated a lot of things, and finally the department, in due compliance of this order, was pleased to pass the speaking order, which Lordship will find it page 127.
Yes.
So this order I have to place, which is impugned in the present proceedings. Dated 11th April 2025, read the Honorable High Court's order dated so and so, that is 24/11 in all the cases, and notification of 10/11/2005, that is the appointment order, also read the government's order of 25th April 2017, 7/12/2023, representation so and so, and Uma Devi also was considered, but I will not rely upon Uma Devi in the present proceedings. Order. This order is passed in respect of the order of the Honorable High Court in WPC so and so dated 24th November 2023. Whereas Purna Sindha Mudoi and Pankaj Kakoti were appointed as Inspector of Drugs by order dated 10/11/2005 under Regulation 3F of Assam Public Service Commission, Regulation 1951, and 10 years of their services were extended from time to time as and when necessary. Whereas Honorable High Court, by two separate orders dated 24/11/2023, directed the government in Health and Family Welfare Department to reconsider and revisit the cases of the prayer of the writ petitioner by considering all the attending facts. Lordship has opened up the gate for us. All the attending facts, including the cases of persons regularized under 3F, under various departments, including the Department of Health and Family Welfare, and taking note of the fact that the government at the appropriate level has taken a conscious decision to take a one-time measure for regularization of the incumbents who have rendered ad hoc services under 3F and remanded back the matter to the authorities to redecide the question of conferring the benefit of regularization of the petitioner in terms of OM dated 16/3/2015 while referring to the Personnel Department's order dated 16/3/2015. Whereas as per the policy guidelines laid down in matter of appointment under Regulation 3F, appointees by Personnel Department by OM dated 16/3/2015, the department further examined whether the instant cases of regularization met the condition so as to undertake a one-time measure for regularization of certain employees appointed under Regulation 3F 1951. The criteria laid down for regularization as per that OM is, Lordship, next page. Number 1, condition. Only those appointees to be considered who had already crossed the upper age limit specified for appearing in the interview test held by APSC for the post that they are holding and therefore left with no chances to get regularized in the post. Number 2, appointees who had not appeared in APSC interview test were outside the purview of the OM. 3, incumbents whose cases were sub judice and were also outside the purview of the OM. 4, the regularization shall only be for those who had rendered services to government varying from 9 years to 22 years when the OM came into force. 5, the list of employees appointed under Regulation 3F who had been considered here as an exceptional case and one-time measure for regularization as appended at Annexure A with the OM and who have rendered services to the government varying from 9 years to 22 years shall be regularized with immediate effect, subject to the conditions that each such employee shall be regularized against the regular vacant post which they are holding currently and drawing salaries thereon. 2, each department whose name have been figured in the Annexure A against the names of the employees shall examine and verify the cases of these employees individually with reference to their eligibility in terms of the education and other qualifications as required at the time for their initial appointment in regard to the post they are now holding. 3, on such verification, the department will issue order of regularization with immediate effect on the strength of this OM. 4, on such regularization, such incumbents shall be eligible for regular service benefits conditions as laid down in their respective service rules. 5, the seniority of the employees in their respective cadres will be counted with effect from the date of regularization. 6, their past services may be counted only for the purpose of calculation of pension benefit and for no other purpose. This is sought to be done as an exceptional case and one-time measure and shall not be taken to recourse in future. This was one of the conditions. Whereas whether the candidates are overage, as overage incumbents are eligible for consideration for regularization as per the OM. The upper age limit is 43 years for government employment for general category candidate as per the personal OM dated
26/9/2016 read with OM dated 3/3/2016, where it is relaxable by further 5 years in case of scheduled caste, scheduled tribe candidates. Going by the records available with the department, the age of the petitioner Purna Sindhu Mudoy and Pankaj Kakoti as on 1/1/2017 was 37 years 3 months and 39 years 5 months respectively. Further, Sri Purna Sindhu Mudoy belonged to scheduled caste, hence the incumbents were not overaged, but rather well within the admissible age for applying and appearing in the APSC interview test for regular appointment by APSC for 12 Inspector of Drugs by the advertisement dated 26/10/2016 and for recruitment of 12 Inspector of Drugs by the advertisement dated 21/2018. So two recruitment processes were mentioned here. Whereas it is further clearly appears that the Medical and Health Recruitment Board by number so and so advertised for 12 number of posts of Inspector of Drugs, and the results were declared on 24th September 2019 and were subsequently appointed on recommendation of the board on 17th August 2020. Therefore, there was scope for the petitioners to appear in the examination and get qualified if otherwise eligible to get selected based on qualification and merit. As a result are already declared, it is evident from perusal of available records that both the petitioners were not present in the selected list. Whereas from perusal of records available, it is evident that the petitioners Purna Sindhu Mudoy and Pankaj Kakoti did not / could not avail opportunities of regular appointment as otherwise available. They have admitted they have never tried to get into this recruitment processes. Whereas the department sought views of Finance Department for regulation of services of 2 drug inspectors, and in note dated 9/10/2024, the Finance Department wrote, further, as per the laid down criteria in the OM dated 16/3/2015, the appointees did not appear for APSC test interview and therefore criteria is not fulfilled. Keeping in view of the above, the Finance Department regrets the proposal for regularization of services of 2 inspectors of drugs, namely Pankaj Kakoti and Purna Sindhu Mudoy. Next point. Whereas the government in Health and Family Welfare Department decided to check the cases of 3F regulations if made within the department as per the personal OM dated 16/3/2015, and also to find out whether the contention raised before the Honorable Court as per the Honorable Court's order dated so-and-so dated so-and-so had several incumbents who were regularized and were given the benefit of regularization under the OM dated 16/3/2015, which did not fulfill the criteria, but nevertheless the benefit of regularization were conferred. This was their contention before the court. By 17 January 2025. Upon checking prima facie of the matter from the report submitted by Joint Secretary Government of Assam Health and Family Welfare, no irregularities were found. So we verified whatever submission they made before this honorable court, the authorities verified also that some other persons without fulfilling the criteria were regularized. Next paragraph. Whereas following cabinet approval and government directive by later dated 23rd March 2015, Sri Rafikur Rahman and Satyendra Prasad Borua, who were initially appointed as research assistants under Regulation 3F, were regularized by the Director of Health Services Assam, dated 27 March 2015, as per the fulfillment of criteria laid down in Personnel Department OM dated 16/3/2015, as no regularities were found. So those who were selected, their case also were clean. Next paragraph. Whereas Purna Sindhu Mudoy and Sri Pankaj Kakoti are temporary employees by virtue of the fact that their services were renewed after every 4 months upon expiry of the term, and their services are co-terminous with such terms, and the employees cannot claim to be made permanent on expiry of the term. Whereas at present there are 31 number of inspectors of drugs posted and working in various districts of the state, and there is no chronic vacancies in the state. Now the department considered Uma Devi here. Whereas in the state of Karnataka versus Uma Devi, in the matter of temporary government employees engaged in daily wages by commercial tax department claiming for regularization,
with all benefits on the basis of having worked for more than 10 years, the Honorable Supreme Court held there is no fundamental right in those who have been employed on daily wages or temporary or on contractual basis to claim that they have a right to be absorbed in service, and that the employees could not show that they have an enforceable legal right to be permanently absorbed or that the state has a legal duty to make them permanent. Whereas it emerges considering all facts and perusal of records that Purna, Sindhu, Mudoy, and Pankaj Kakoti do not, inter alia, fulfill major eligibility criteria conditions described above as laid down in the OM dated 16th March 2015. Now, in view of above, on perusal and after careful examination of all the relevant records on the matter, the government in Health and Family Welfare Department has decided to regret the proposal for regularization of services of two inspector of drugs, namely Pankaj Kakoti and Purna Sindhu Mudoy. The representation submitted by Pankaj so and so and represented by Purna Sindhu are accordingly disposed of. So, from all angles, from all perspective, Lordship, if we consider their eligibility status vis-a-vis the eligibility criteria as sought in the OM of 16 March 2015, there is no compliance. They do not fulfill all the criteria. That is, that they have to appear in selection process. They have not done it. They have to be overage. They are underage. So these are the two major criteria, and other conditions also they do not fulfill. And on top of that, the policy itself says that this is a one-time exceptional case. The regulation has been made, and this OM cannot be considered for any future recruitment or regularization. Unless and until this OM is modified or bring into force once again or revalidation, this OM, in fact, in my humble submission, has lost its force. Because there is a specific number of persons who are named there, and it is in respect of those persons only, Annexer A, appended to the OM. So the government in the cabinet had taken a conscious decision at that point of time, rightly or wrongly, to regularize 3F appointees, which in my humble submission, if we look at all the judgments of this High Court, both division bench and single judges orders, there is a direct contempt in that OM. The executive cannot bypass the settled law laid down by this honorable court, which is binding on the government activities, where by a cabinet decision or by a executive order issued under Article 162 cannot bypass a judicial order or pronouncement of this honorable court. Otherwise, all judicial orders will come into a nullity.
There is only one thing that perhaps considered the last occasion. See, they are not overage, there is no quarrel. There is no quarrel that they are not overage. But their inability to appear for APSC was on the account that no examination was held.
Therefore, suppose a recruitment process started in 2007, it did not fructify. They do not fulfill.
Ultimately, the question would be their age factor.
Age factor. There are two criteria. One cannot, it is not a isolated or standalone criteria. There are two criteria which are to be fulfilled simultaneously. And the basic idea of that cabinet decision was that these persons who are being regularized under that OM of 16th March 2015, that they do not have any future opportunity. All their roads are closed. That means they cannot participate in any regularly done recruitment process, because they do not fulfill the age criteria. So it is not a case that these two persons are left out. There are hundreds of identically placed persons who are left out from that purview of that OM, because all of them have age in their side to participate in the subsequent recruitment process. And that subsequent recruitment process started in 2016 onwards, 2016, 2018, and 2021, 23. Now, four recruitment processes are over. They did not make any endeavor. And if I don't make an endeavor, can that be a premium? that I don't participate, I don't go to the examination hall, and I want the result in my favor from an honorable court. That is not the intent and tenor of that OM. So these are the basic facts. The facts are undisputed. So in this situation, because they cannot be equalized with the temporary workers, ad hoc employees, or contractual employees, as seen in Uma Devi's case. They are a different group of employees. Their whole service is governed by Regulation 3F of the APSC Regulation of 1951. Uma Devi did not consider those statutory appointments. So there is a distinction. The learned senior counsel from the other side was saying that we are only relying upon Uma Devi. No. The officer may have considered Uma Devi's ratio also. Paragraph 43 is very clear on that. And there is a subsequent paragraph 53, where it says that if you are without any court's order, you are working as a contractual or ad hoc or daily wage. If you are working against a sanctioned post, if you fulfill all the criteria, then as a one-time opportunity, you can do it. That is a one-time. We have two notifications to that effect in 2013 and 2000. But that date, cut-off date was, Lordship, 10th of April 2006. So they do not fulfill all those criteria. So now I would like to place these judgments. I will not take much time of this honorable court. And so far as these two writ petitioners are concerned, Lordship, we have filed they have filed in the writ petition itself. Lordship will kindly see page, they have given a chart, page 8 onwards in the writ petition. Page 8. So, paragraph 4, the tenure and services of petitioner as inspector of drugs has continuously been extended from time to time. The periods for which extension has been given are as follows. If we start from 2006, the first is of 11th November 2006, then 15/3/2007. Serially, it is going on. If we look at serial number 16, it's 2013, 14, 2012, 20, serial number 2014. We are proceeding further, suppose 23, 2017. That way, Lordship will come to page 13. The last extension was given on 14th July 2023, serial number 32, with effect from 15th July 2023 to 14th November 2023. So after that, the government decided not to give them any extension. They do not have any enforceable right to get extension. In fact, on the basis of this honorable court's observations or some orders, they are still continuing. That is why their names do not figure in the transfer list. So from 14th November 2023,
They're not drawing any salary.
I think no salary. Plus, they are not getting salary also.
In December 28th.
From 23 onward.
No, yes.
Sure, no?
No, it's
Yes.
there in the report.
So this is the factual position, Lord. So in my affidavit in opposition, Lordship may kindly take note of paragraph 4, 5,
7 or 9.
4, 5, 7, and 9. Our stand is very clearly, which I have repeatedly submitting, Lordship.
So what we have stated in the speaker, we are reiterating in our pleadings also. Now, initially they were submitting that there had been a lot of irregularities and illegalities in enforcing the OM dated 16/3/2015. And in our speaking order, we have very categorically said that, Lordship, we have verified all the allegations they raised before the Honorable Court. These are not found to be correct. In their affidavit in reply at paragraph 14, they have filed an affidavit in reply, which is dated 8 of May 2025. 8 May. So recently they filed an affidavit in reply, and they have very categorically admitted paragraph 14. The running page starts from 229.
Yeah.
So I'm paragraph 14, 229. I'm skipping. Lordship will kindly come to the next page. About 10 lines from top, so far as have Lordship, page 230, about 10 lines from top. So far as the irregularities, in the giving benefit under OM dated 16/3/2015 is concerned, the deponent states that the deponent never raised the contention that the irregularities were committed while giving the benefits of regularization in terms of OM. It is pertinent to mention here, while passing the speaking order on 11/4/2000, the Commissioner and Secretary of the Government of Health has mentioned that no irregularities were found regarding the application of OM dated 16/3/2015. However, it is nowhere mentioned that all the persons who were given the benefit of regulation pursuant to OM were overaged and had appeared in APSC interview. The deponent simply raised the contention before the Honorable Court that several persons who never appeared in APSC and who were not overaged were given the benefit of OM. So what they are saying, they are a little bit conflicting what they are saying here. So on one hand, they are saying that there is no irregularity in implementing the OM of 16th March 2015. And on the other hand, they simply raised the contention before the Honorable Court that several persons who never appeared in APSC interview and who were not overaged were also given the benefit. So self-conflicting statements they are making. Lordship will then come to page 232. Fifth line from top, 1, 2, 3, 4, 5. It, the last word is it. It is once again pertinent to mention herein that the deponent is not aggrieved by the OM dated 16/3/2015, nor he has any grievance against any person who got the benefit of regularization under OM dated 16/3/2015. However, the plain and simple contention of the deponent is that the applications of the OM of 16/3 shall be uniform and all the similarly situated persons shall get the benefit of such OM. The reiterated paragraph 16. Now, if he is happy with the OM of 16th March 2015, then that particular OM itself says this is a one-time exercise and no future regularization will be done on the basis of that OM. Clause number 6. May I place it once more? The repetition. Judgment. If Lordship is pleased to come to the repetition, page number 86. So he is happy with the OM. He has no grievance against the OM. So clause number 7, page 87.
Yeah.
This is sought to be done as an exceptional case and one-time measure and shall not be taken into recourse in future. So he is happy with this clause also. You cannot pick up one clause and leave the other when he is entirely happy with the whole OM. So he himself is closing his door.
the opportunities he want to derive is now shut from his affidavit in reply.
itu kita kami Joint Director itu support to repeat over. Joint Director itu repeat over. Ibu lihat kami dulu tidak akan memang
And
if customer to go to site ID customer
and in one case, Lordship, 6308 2024, here we have raised that the joint director has some soft corner for these two petitioners, and he is allowing them to work. Therefore, we have drawn departmental proceedings against the joint director also. It's a part of the affidavit. They are not supposed to work.
Part of the affidavit here or in the
Yes,
material?
in WPC 6308,
in the city.
in the series
6308.
08 2024,
308.
14
paragraph
14
14. I would like to read out paragraph 14. This is not a private limited company that the joint director can do whatever he wants. There are certain norms, certain procedures. I would like to read paragraph 14. With regard to the statements made in paragraph 21 of the writ petition, the deponent begs to submit that it is administrative discretion for granting extension of services of temporary employees, and in this case, there is no justification in continuation of temporary services by extension of term. In pursuance of the notification dated
So you are reading
24/11,
from
paragraph 14.
14. Just one minute. This is in page 64.
Is 86 if I'm not wrong.
Police এখানে stay করে long stay. He could let they are within the killer. Because support they are hit or let them withdraw.
Here.
May I read it? With regard to the statements made in paragraph 21 of the writ petition, the deponent begs to submit that it is administrative discretion for granting extension of services of temporary employees, and in this case, there is no justification in continuation of temporary services by extension of term. In pursuance of the notification of 24th November 2024, Pooja Devnath, respondent of 7 and Hemchandra Bhatta has already joined in their present place of posting on 28/11/2024, following personal department's OM dated 25/11/2024, which states that the practice of issue of release order consequent to issue of transfer order is henceforth barred. No official needs to wait for a release order to hand over charge on his own promptly, and the official shall stand released automatically. It is pertinent to mention that Joint Director Health Services Kamrup issued one letter dated 30/11/2024, hereby the Commissioner of Secretary Health and Family Welfare Department, Government of Assam, was informed that Mrs. Pooja Devnath, Inspector of Drugs, reported for joining on 30/11/2024, but there is no vacant post of Inspector of Drugs under his establishment, and also furnish the incumbency list of drug inspectors wherein the name of the petitioners and Purna Sindhu Mudoi appeared. However, subsequently, the aforesaid letter dated 30/11/2024 was cancelled by the Joint Director of Health Services, Kamrup, issued dated 3/12/2024. Further, it is stated that so-called notice by dated 17/12/2024 for furnishing the false incumbency position of the Inspector of Drugs Kamrup by the aforementioned order dated 30/11/2024. However, as no satisfactory reply was submitted, departmental proceedings has been initiated against him. So he tried to show that in the incumbency list, the names were there. In fact, it was not there.
This letter was issued on 24th.
Yes. We have annexed those letters also. But these are some supplementary facts, Lordship, but that will not give any right to them or to us also for the just and proper adjudication of the issue before this honorable court.
Yes.
So it is very clear that they were not in service with effect from 14th November 2023, because there is no subsequent extension. So regarding regularization of 3F appointees, my first judgment which I would like to rely is 1995, 1 SC, 1 GLR 229, page paragraph 11. 1995, 1995, 1 GLR page 229. It is a division bench judgment. My Lord Justice Khanna and SN Phukan. Pranjit Kumar Das versus Jones. Paragraph 11. Lordship will find it at 235 page number. This regulation 3F of the regulation of 1951 came up for consideration by the division bench of this court in Hemanto Kumar Pegu and others versus State of Assam, 1988 1 GLJ and 1989 1 GLR. The division bench considered regulation 3F and held in paragraph 27 of the judgment that this regulation does not provide a source or power for appointment, but only provides the mode of appointment, and the regularized does not connote permanence. The contention that the person who are appointed under regulation 3F can be regularized if they otherwise qualified was not accepted by the court, and it was held that regularization means making regular appointment by selection, irrespective of the question whether the petitioners were already appointed under regulation 3F or not. The ratio laid down in the above decision, in our opinion, is the correct proposition of law, and there is no reason to take a different view. Therefore, in view of the above ratio, we are constrained to hold that merely because the appointments of the appellants were converted to appointment under regulation 3F of the regulation, they cannot claim regularization due to length of their service. So this is on the basis of 1988's judgment in 1995. Then 1996, 3 GLT, page 310. 1996, 310. This is also another division bench. Chief Justice B.K. Khanna and Justice A.K. Patnaik. 1996, volume 3 GLT, page 310, and series of cases were disposed of together. Deborpatra Borgohai and 19 others, plus several other cases, which are batch cases. Here the relevant paragraph will be paragraph 16.
Yeah.
May I read it?
Yeah.
The law thus having been enunciated by the apex court, let us examine the cases of those petitioners who have been appointed under regulation 3F, and as to whether any of their rights under the statutory provisions, the appointment letter, or the constitution has been violated. The statutory provision of regulation 3F makes it clear that the appointment is purely temporary, pending reference to and selection by APSC. The appointment letter issued to 3F appointees clearly contain a clause that the appointment being under regulation 3F, continuance in service vis-a-vis regulation in service thereof, will depend upon being selected by APSC within the required position in the list of candidates recommended by APSC for regularization. It will be the responsibility of the appointee to apply and to appear in the selection notified advertised by the APSC for filling up the post of junior engineer, and that in case he does not appear or is not able to appear, or in case he is not selected by APSC within the required position of the select list, the appointment stands automatically terminated. From the facts narrated earlier, it is clear that except 2 petitioners in civil rule so, all other appointees under regulation 3F had the opportunity of appearing.
Just 1 minute.
No.
Yes, please.
Yes, may I continue? From the facts narrated earlier, it is clear that except the 2 petitioners in civil rule so, all other appointees under regulation 3 have had the opportunity of appearing in the APSC selection for public employment, and hence their right either under Article 14 and 16 of the Constitution or under regulation 3F or their appointments later have not been violated. All these appointees except two did apply and appear and thus avail a chance and at the behest of such appointees under Regulation 3F who have been found unsuccessful, this court in exercise of its extraordinary jurisdiction under 226 of the Constitution will not grant them any relief of quashing the selection of the candidates by the APSC in excess of the advertised post or in continuing them in the post to which they are temporarily appointed pending regular selection by APSC. In this case, they appeared and they were unsuccessful. In our case, they did not, they choose not to appear also. In either situation, the court will not grant them any relief. Whether you, if you are successful, automatically you are regularized. If you are not successful also, by participating in APSC, the Honorable Court will not pass any order for their regulation under Regulations 3F. And if they choose not to appear, there is no question of giving such direction. These are two division bench judgments. Then 2000, because these are very old cases. So now coming to a little bit later, 2018. Two 2 GLT page 376 in the Soil Conservation Department, Onamika Tamuli versus a single judge's order. My Lord Justice A.K. Goswami's order, paragraph 23.
Yeah.
It was held in Nobin Chandra Bordoloi, Supra, that Regulation 3F of 1951 regulation does not provide a source of power for appointment, but it is only provides a mode of appointment, and that regularization does not connote permanence. Regulation 3F provides for a mode of appointment on temporary basis for 4 months because of the fact that regular appointment cannot be made within the short span of time. In the aforesaid case, the appointees under Regulation 3F joined duty on 22/5/1984 and were regularized in 2012-2089 with retrospective effect from 16/1 to 1987. In no uncertain terms, this court held that the appointment being stopgap arrangement on ad hoc basis, their service on ad hoc basis could not be counted for the purpose of seniority. It was further held that the services rendered by any incumbent under an appointment made under 3F cannot be a ground for regulation on the incumbent on that basis. So here are cases that no APSC was conducted from 2005 or 6 till 2015. That is why they are getting that extension of 4 months. Otherwise, that extension would not have been given.
When was it held?
In 2016.
16.
16.
They did not appear.
They did not appear. Then again in 2018, they did not appear. Again in 2020, did not appear. They chose not to appear.
Are these facts available in your affidavit?
Yes. Yes.
Paragraph?
Not only in affidavit, in our speaking order also. In the speaking order, 2 recruitment processes were shown.
2016
and 2018. The dates are also given. May I just let us go to the speaking order. Very nicely written. All the facts were highlighted here in the speaking order. In page, Lordship will kindly come to page 128 of the writ petition. Have Lordship got the speaking order?
Yes.
May I read the last paragraph? Whereas the candidates are overage, as per overage, incumbents are eligible for consideration of regulation as per OM. The upper age limit is 43 years for government employment for general category candidates as per personal OM dated 26/9/2016, read with 3/3/2016, which is relaxable by 5 years in case of scheduled class, scheduled tribe candidates. Going by the records available with the department, the age of petitioner Purno Sindhu and Pankaj Kakoti as on 1/1/2017 was 37 years, 3 months and 39 years, 5 months respectively. Further, Sri Purno Sinha Mudoi belongs to scheduled caste category, hence the incumbents were not overage, but rather well within the admissible age for applying and appearing in the APSC test interview for regular recruitment by APSC for 12 Inspector of Drugs via advertisement dated 26/10/2016, and for recruitment of 12 Inspector of Drugs via advertisement dated 21/2018. So two I have shown here. Till that age, till that time, they both have the age. In fact, till 2022, I think they had the age. So very categorical, Lordship, here. So the next judgment will be 2022 6 GLR case 308. This was a very lengthy hearing, Lordship, and we got a very lengthy judgment also. 2022 6 GLR page 308. Saurabh Jyoti Porafar and others versus State of Assam. They were junior engineers, if I am not, I argued this matter. PWD. They wanted regularization. They gone through a proper process of recruitment. And when we started the regular process, they came that they want regularization. So paragraph 1 to the facts are there. I would like to read out paragraph 35 onwards. Paragraph 35. In paragraph 35, Lordship will find it is a quoting of the regulation 3F. I already placed it. Now coming to paragraph 36. Regulation 3F of, and all these division bench judgments were referred, Lordship, they were all discussed. Regulation 3F of the APSC Regulation 1951 has inter alia provided that when an appointment is to be made by direct recruitment to a temporary post, temporary post created in civil service and post, if it is necessary in public interest that the appointment should be made immediately, and the reference to the commission would cause undue delay, the commission is not required to be consulted in matters relating to the method of recruitment or with regard to the suitability of the candidates for such appointment. The proviso to it has provided that if the post has been sanctioned for and is likely to last for more than 4 months, the commission shall as soon as possible be consulted inter alia in all matters mentioned in clause 3 of article 320 of the Constitution. Regulation 3F of APSC Regulations 1951 has indicated that an appointment made under Regulation 3F shall be in a post which is temporary in nature. If the state government is of the view that there is an immediate need to make an appointment in such temporary post and a reference to the commission would cause undue delay, the state government can make such appointment in the temporary post in a service or post by way of direct recruitment under Regulation 3F. From the narrative of Regulation 3F, it is clear that an appointment made under Regulation 3F is purely ad hoc in nature until the regular selection is made by the Commission in accordance with the provisions laid down in the concerned service rule, if any, and in absence of any service rules, in a manner consistent with Article 14 and 16 of the Constitution. The proviso further made it clear that if the post has been sanctioned or likely to last for more than 4 months, the only option available is to fill up the post in regular selection process held in consultation with the Commission. As a natural corollary, once regular selection is made, the appointee who is working in the post by virtue of his appointment under Regulation 3F has to make way to the candidate selected through the regular selection process, and the government/appointing authority, when a candidate is selected through the regular selection process is available, has to give appointment to such regular selectees, and it shall not be open for the government/appointing authority to keep such regular selectee at bay while allowing the appointee under Regulation 3F to continue working in the post. If such an eventuality arises, the regularly selected candidates have to be appointed even by terminating the services of the appointee appointed under Regulation 3F of the APSC Regulation 1951. The Joint Director is trying to do a act by which he tried to allow this 3F appointee to continue in those posts. That's why he is facing the departmental proceedings now. Issue pertaining to Regulation 3F of the APSC Regulation 1951 came up for consideration in a number of cases before this court, as has been indicated. In Pranjit Kumar Das, the advertisement was published by the Commissioner of Secretary of Government of Handloom and Textile Department on 29th July 1989, calling for applications for ad hoc appointment in the post of Senior Inspector of Handloom and Textile. The writ appellant petitioners, along with others, interviewed by a selection committee and a select list was prepared. Thereafter, the writ appellant petitioners were appointed under the provisions of Assam Regulation so and so 1986 on different dates in 1919. After 1 year of their services, they were terminated with effect from 22/5/1991, and they were reappointed in the same post on the next date, that is 23/5/1991. The government of Assam, in a letter dated 30/5/1991, requested the APSC to take necessary steps for regularization of the writ appellant petitioners code. The APSC ad hoc rules 1986 was thereafter repealed by a notification of 18th May 1992, and the earlier appointment of the writ petition were converted to appointments under Regulation 3F of the APSC Regulations 1951, initially for 4 months and subsequently extended from time to time. Another advertisement was published by the Commission on 9/10/1991, calling for applications for filling up the vacancies in the post of Senior Inspector of Handloom and Textile, which post the writ appellant petitioners were holding. The writ appellant petitioners had applied in response to the advertisement dated 9/10/1991, but in the select list prepared on the basis of merit, the names of the writ appellants petitioners did not figure, as they failed to qualify in the interview conducted by the Commission for the post. In the backdrop of those events, when writ appellants approached the court, the division bench of the court in Prankit Kumar Das case. This Regulation 3F of the Regulation 1912 came up for consideration in the division bench in Hemantla Pegu. The division bench considered regularization, etc. So basically, that same ratio has been followed. Lordship will kindly come to next page, 37.3. The observations made by the two decisions of division bench of this court in Debabrata Borgohain and Konatan Borua can be referred to as both decisions were rendered in connection with Regulations 3F of the Regulations 1951, qua appointment made in the Assam Public Works Department, Government of Assam. So the ratio is basically 37.6. It follows from the observations made in the decision of Santanu Borua that if a person who has been serving in Public Works Department after appointment in terms of Regulation 3F of APSC Regulations 1951 wants himself to become a member of Assam Engineering Service Rules 1978, then he has to apply and appear in the selection process when applications are filling. In our case also, there is a separate service rules governing their service. That is called Assam Drugs Control Organization Service Rules 1994.
No, subsequently, there's another set of rules which has come.
No, that is a board has been constituted. Because not only in medical department, but also in education department of engineering services, we have constituted several recruitment boards in the department, because APSC is quite late in conducting the recruitment processes. From 2006 onwards till 2017-18, the government was facing a lot of difficulties, because in spite of repeated requests for conducting the recruitment process, APSC failed, because Lordship knows why it is. All the persons are behind jail. They were concentrating only on a particular area. So all other departments where the consultation of APSC was required as per the mandate of the APSC regulation as well as the respective service rules, the APSC was failed to deliver their proper service on time. And that is precisely a reason why there is such a delay. From 2007, when the consultation request was made, it could be done in 2016 only. Therefore, those overage persons were given that benefit.
No, in the earlier order, earlier judgment, I think some reference was.
The reference is regarding the board. Board. So board has been considered that board is empowered to do the conduct. Lordship.
2017.
2017. And that board has been constituted only to bypass APSC. We do not want APSC service anymore. So there is an amendment. And the board has been constituted not only here, but also in engineering education system. That was put to challenge and that was highly upheld by the honorable court. That board constitution was also put to challenge. Not here, but in the other department, education department. So that we have justified it, that because APSC has miserably failed to deliver its services. That is the reason. Here also, it is not that the government deliberately delayed in conducting the.
That has no relevance.
There is no relevance, Lordship. Absolutely no relevance.
All right.
So this is the most latest judgment where all the judgments were referred to. This judgment of my Lord Justice Manish Chaudhary, Saurabh Juti, which I have placed just now. Then, Lordship, I would like to give. Regulation of ad hoc temporary employees. On that point, Lordship, I would like to place 2007 1 SCC, page 406. 2007 1 SCC, page 408. Indian Drugs and Pharmaceutical Limited versus Workman Indian Drugs and Pharmaceutical Limited. The relevant paragraph will be paragraph 14 to paragraph 23. Who is a temporary employee, Lordship? That has been discussed here. Paragraph 14, may I read it, Lordship?
Yes, one.
Negative equality. The internal page will be 419 in that.
Yes.
Paragraph 14. So the relevant paragraph which I will refer to, paragraph 14 to paragraph 23. I will give that sheet of paper. 24 to 37, 41 to 49, 52 and 53. So paragraph 14 starts. The distinction between a temporary employee and a permanent employee is well settled. Whereas a permanent employee has a right to be post, a temporary employee has no right to the post. It is only a permanent employee who has a right to continue in service till the age of superannuation, unless he is dismissed or removed after an inquiry or his service is terminated due to some other valid reasons earlier. As regard to temporary employee, there is no age of superannuation because he has no right to the post at all. Hence, it follows that no direction can be passed in case of any temporary employee that he should continue till the age of superannuation. So that they do not have any right for that 4 months extension also, leaving aside the direction for regularization. So I will not take much time. All the paragraphs are very important. 41. Paragraph 41. No doubt in some decisions of Supreme Court has directed regulation of temporary or ad hoc employees, but it is well settled that a mere direction of the Supreme Court without laying down any principle of law is not a precedent. It is only where the Supreme Court lays down a principle of law that it will amount to a precedent. Often the Supreme Court issues direction without laying down any principle of law, in which case it is not a precedent. For instance, the Supreme Court often directs appointment of someone or regulation of a temporary employee or payment of salary without laying down any principle of law. This is often done on humanitarian considerations, but this will not operate as a precedent binding on the High Court. For instance, if the Supreme Court directs regularization of service of an employee who has put in 3 years of service, this does not mean that all employees who had put in 3 years service must be regularized. Hence, such a direction is not precedent, so and so, okay. So I'm just, because they showed some judgments. So these are not in personam, some orders, and there are the cases regarding the Uma Devi's case. So those are, and Uma Devi case is a judgment given by a constitution bench of 5 judges. So 2 judges bench, whatever they say, ultimately the binding precedent will be the full bench judgment. till it is overruled by another 7 bench judges bench. So on top of that, if we look at all these judgments of the Guwahati High Court in the division bench from 1988 onwards, it is a settled position of law that 3F appointees do not have any right for regularization. Absolutely no right. That is barred by the judicial pronouncements. The government in 2015, that 16th March 2015's OM, is in direct violation of the directions passed by this Honorable Court. That has more so, that has lost its force also. It has a one time, they have done it, it is completed. Their whole case is based on that particular.
Not under challenge.
That is not under challenge. Number one, if they challenge, then their case will further weaken. If they challenge it, because if they challenge, they can challenge clause 7 only, which said this is a one time and no future recourse will be done on the basis of that OM. So my humble submission is that OM itself is in violation of the judgments passed by this Honorable Court in respect of 3F appointment. They cannot, the executive or the cabinet do not have that right. Otherwise, all judgments of this court or of the Supreme Court can be bypassed and diluted by taking a cabinet decision. That is not permissible in law, Lords. That is not the structure of our judicial system. We have to honor. How the Advocate General gave that opinion, I do not know. When Uma Devi and all other cases, plus that Pegu and all division bench judgments are there, nothing has been referred to.
The reference to a judgment there.
Reference to a judgment which is well bypassed. That is judgment of 1990. Uma Devi came in 2006. Then ML Kesari, then official liquidator. One Supreme Court division bench violated Uma Devi. Then Lordship will read that judgment of official liquidator. How the Supreme Court deprecated their own judges, that they are judicially bound to maintain the judicial discipline. So here the Advocate General gave an opinion on the basis of an obsolete law, which has been well bypassed in 2006. Till 2006, government have done 30,000 master roll workers and contractual workers regularization in 2005 and 2006. Lordship knows that. About 35,000, 28,000 master rolls and 6,000 or 7,000 work charge employees. That was the policy. And there is a OM also of 1993. And that was all diluted by a division bench, constitution bench, 3 judges bench. My late Justice Ranjan Gogoi was there and 2 other judges in Jitendra Kolita's case. So thereafter, there is absolutely no scope for regularization of any temporary, contractual, work charge ad hoc employee. And so far as 3F appointees are concerned, all the other judgments are governing the field. Their whole basis is 2015's OM. That OM is prima facie, Lordship. It is in against the law. It is in direct conflict with the law laid down by this Honorable Court. And more so that even if we take that OM is valid, then also that OM itself restricts their regularization. 2 conditions they do not fulfill. And the third most crucial is that OM is not applicable for any future regularization. And paragraph 43 of that judgment, in the previous case, Lordship, that 2007-1 SCC matter, 2007-1 SCC page 408, paragraph 43. In view of the above observations of this court, it has to be held that the rules of recruitment cannot be relaxed and the court tribunal cannot direct regulation of temporary appointees, derogates the rules, nor it can direct continuation of service of temporary employees, whether called a casual, ad hoc or daily rated, or payment of regular salaries to them. So when the law is well settled and the law is in place, that is the regulation of 1951, the 3F appointee, it is for 4 months and from time to time extension. Beyond that, there is no scope of regularization in the regulation itself. And the regulation is made under the Constitution, Article 318.
Yes.
318 says it has the source of power is the Article 318. This is unconstitutional otherwise. 318 says power to make regulations as to conditions of service of members and staffs of the commission. In case of the union government, union commission or joint commission, the president, and in case of state commission, the governor of the state may by regulation determine the number of members, etc. All the service conditions can be done under the power given under Article 318, and therefore the regulation itself, this regulation, 1951 regulation, the preamble itself says, in exercise of the power conferred by the proviso to clause 3 of Article 320 of the Constitution, and in supersession of the previous orders and the subject, the governor of Assam is so and so. 320. I found the other day I got 318 also. In any case, 320 is mentioned here. 318 is Public Service Commission. 320. 320 says functions of the Public Service Commission. And C says all, it's a very long, the union or the state public service, as the case may be, shall be consulted. All the cases are given here.
Yes.
So for regularization, APSC has to be consulted. And APSC do not have the power to give regularization to the 3F appointees. Negative equivalent.
318 is there in the 51 regulation.
Yes, Lord. I found it the other day.
51.
351.
APSC regulations 1951.
Yes, Lord.
318 is
Yes,
specified
yes,
there.
I stand corrected. I am obliged, Lordship. Yes.
But insofar as these matters are concerned, we are concerned with the other 51 limitation of function,
Limitation of function.
which is
and
under 320.
323. Now, coming to another judgment, 2007 5 SCC, page 317. Postmaster General versus Tutu Das. It is also in respect of regularization. Paragraph 13. Paragraph 13, 14, 15. Equality clause contained in Article 14 and 16 of the Constitution of India must be given primacy. No policy decision can be taken in terms of Article 77 or 162 of the Constitution, which should run contrary to the constitutional or statutory schemes. This is what I am arguing from day one. That Articles 162 does not empower the state executive to bypass a law which is in position. That law has the mandate of the Constitution as well as the state regulation. So this OM of 2015 is not only in violation of the various judicial pronouncement of this Honorable Court, but also in violation of the regulation of 1951. And on top of that, it is in violation of the drugs rules of 1974. So everything has been flouted on the basis of some opinion given by the Advocate General. On the basis of a 1990s obsolete judgment, which was not in force at any point of time. So this is my humble submission, Lordship. I think I have, and as because I have also brought some judgments on negative equality. Suppose wrongly it has been given, that cannot be taken as a basis for giving benefit to some others on the basis of some wrong judgments or wrong decisions. As because they have now admitted that there has been no violation or no irregularities on the implementation of the 2015 notification or OM. So I do not think it will be appropriate, but in case, suppose X was given the benefit of the OM irregularly or illegally, that will not give benefit to them now.
Your argument is
The principle
that
of negative equality.
this particular OM or notification
Yes.
being violative of the constitutional provision as well as of the judgment.
Yes.
Any benefit given to the person named there will not automatically entitle them to get the benefit.
No, that is one part. The other part is that they are also saying that some other persons were given the benefit by violating that OM.
So similar benefit.
A similar benefit. So because they have admitted, they have come to the conclusion that they are not over age and they have not participated in the APSC or any other recruitment process. So they do not fulfill two of the criteria as laid down in the 2015 notification or the policy.
They don't fulfill both the criteria.
They do not fulfill. Otherwise also. So they said that some other persons were given benefit by violating that OM. So on the basis that our verification and in the impugned order, it is very clearly stated in the speaking order that we have verified and there is no such correctness of their submission, which they have subsequently in the reply has admitted. So in my humble submission, there is absolutely no merit in the petitions, both the writ petitions, and they do not have any right to continue, not to speak about getting any salary. This is my humble submission. So both the cases may be dismissed. So I would like to give a document, Lordship, where I have categorized all the judgments which I am referring, including the negative equality.
We have it.
Oh, Lordship. Deeply obliged.
Lordship, on 22nd, your Lordship, it is not inconvenient, Lordship. So, hearing day, your Lordship, Thursday.
22nd.
My colleague will be here, Lordship. And I'm happy, obliged that I am given the opportunity because we circulated a letter yesterday for adjourning this matter. Because last moment my program was changed, therefore I am in the court.
No problem.
Otherwise, it will look odd that I am in the court and not taking adjournment on the ground that I am not available.
Lordship, my only prayer is that Lordship, interim may be continued till then.
Your interim is there. What happens to the other writ petition?
Their case is that their names did not figure in the transporter. These are all consequential things. If any clarity is required, Lordship, in the final stage, we can give that indication. But their names were not figured in the transfer list. That is why, because they are not in the service at all. There is no extension of their service from November 2023. We are in 25. Highly obliged.
Mr. Devajit Sakia, your Advocate General Assam. Have the respondent. Counsel for the petitioner submits that the senior counsel petitioner would like to give his rejoinder, arguments and rejoinder. Accordingly, is likely to be fixed on 22nd of March.
May.
22nd of May.
Highly obliged. No good.
Lordship, this is the labor code award, Lordship. Lordship, award, then they have challenged the award. Now the High Court judgment, they dismissed the petition. Now only implementation of the judgment, that they have not implemented the judgment fully. That is my case, Lordship. Lordship, award date page 19 to 35 in the writ petition.
Where is the judgment?
Judgment, Lordship, 19 to 35 in the writ petition. Award.
No, the High Court judgment.
No, High Court judgment is next page, Lordship, that is page 36. 36 in the writ. Property person is 38.
Yes, for the union.
Lordship may kindly peruse page 71, running page 71 of our affidavit in opposition.
Yeah.
So after the order of the tribunal, even this honorable court has passed the following observation, my lord. I am reading it out, my lord, page 71, second para. After going through the record, more particularly the award passed by learned tribunal, I do not find any good ground to interfere with the same. Since the award of the learned tribunal is only to pay 50% of the wages to the petitioner with effect from the date on which his name was struck off from the attendance register, that is 10/7/2008, till reinstatement, and considering the ground on which the aforesaid award has been passed, I do not find any justifiable ground for the interference with the same. So, my lord, in terms of this order, my lord, with effect from 10/7/2008 till the date of reinstatement, that is 13/4/2023, 50% wages was paid.
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 What is left to be done?
No, I'll let him submit. I'll try because you have already submitted the counter affidavit. In the ways they have not taken into consideration the increment, annual increment. Which as per this judgment of the various High Court or the Supreme Court, that wage includes the annual increment also. That is not calculated. Secondly, the POD is treated as dies not. Very interestingly, that I was not allowed to perform my duties. That's why this award was given. So thereafter, they have challenged the order before the Honorable Supreme Court, so High Court. So 17B, we have filed a petition. So 17B, they have already agreed. There is an order for the High Court that Honorable Court has asked them that whether the option is with you, whether you allow him to join or you pay the 50% allowance in 17B petition. So they have accepted that the second option, that we will not allow him to join and we will pay the award. So that order is there, Lord, kindly. That order is here. In my writ petition, I have annexed that order. That is page 40. Page 40 of the writ petition.
40.
40. 40. Page 40 and 50. Honorable Court asked them their option. Last paragraph, Lordship. At this stage, they learned counsel for the management prays for some time to obtain instruction from the client and to inform the court accordingly. So next page. The DKD learned preparing for the railway has further submitted that this management has decided to avail the second option and will pay the full expenses. So now they want to recover that one, but that cannot be recovered as per the Supreme Court judgment. That 17B, as per the order of the 17B, they have allowed this. Now, Lordship, the final order has been passed. Now they have filed an affidavit stating that they have already complied with this order. But now I like to point out the paragraph 10 of page 61 of their affidavit. So whether judgment can be interpreted by railway officials, page 61. of their affidavit. Paragraph 10. Here, second paragraph, they have said, accordingly, all admissible pay and wages of the applicant has already been paid with vetting by associate finance so and so, not so and so. So here, pay, DA and GP group increment is not calculation. Can they can we have a calculation part here? Kindly Lordship turn to page 71 of their affidavit. In the remarks column, the 50% wage to be paid and the period to be treated as diazonon. Where they have got this diazonon? Because there is no order from the court, not it award or from award, the diazonon. Period is treated as diazonon. It is the railway, they have not allowed me to perform my duty. That is why the reference case. Thereafter, they filed this petition before the court, challenging the award. Now, that they are mentioning that is not number one. Number two, entire period is treated as diagonal. Page 70, it is a calculation that they deducted my that payment first column, already paid gross amount full last as per interim order of the court, 27,415. This is 17,23,500 they have deducted. How they can be deducted this amount? Because this is an interim order. So that increment, annual increment, that will not allowed, not given. So here I like to refer judgment in this point. That one is Bombay High Court judgment that full wage last drawn would mean the wages drawn by the date of termination plus the yearly increment. So yearly increment they have not calculated in this calculation chart. That 17 years, 170 months. So annual increment, I am entitled for that annual increment. That has not been given. So this is the judgment of the Bombay High Court. Here it clearly says wage includes the annual increment also. They have not calculated the annual increment for my whole period.
It is included in your gross pay.
No, the increment is not calculated. They have only, yes.
The direction of the court is, labor court is payment of 50% of gross pay.
Gross pay.
The increment included in your gross pay. Is it included?
Included.
From where do you say that?
No, they have challenged the order. That's why I mean written affidavit also we have. So here
But you have to show us from the calculation that it is included in the gross pay.
Calculation, sir, they have given the calculation, sir. I counter it.
You are asking for increments.
Okay.
They have given you gross pay.
Gross pay.
Without increment.
Without increment.
Now you show us from your calculation
yes.
that the increments
not given
are included in the gross pay that is required to be paid.
Yeah.
What is the judgment you are referring to?
That is Bombay.
Yes. For what purpose?
Then another judgment is there regarding that they have deducted my allowance which is paid as an interim measure on 17B. That cannot be deducted as per the Delhi High Court as a Supreme Court observation. That means it is the judgment I'm referring.
That will dispute one.
They cannot treat me the dice note because they prevented me from performing my duty. So they are now treated entire period as a dice note.
No problem. Definitely.
Right, yeah, good. I mean, okay. And now it's like,
You're paid wages or salary?
Not
What are you paid? Salary or
salary,
wages?
salary.
Salary or wages?
Wages.
But the annual increment is included in the gross pay, madam.
It is.
Madam.
Then you have shown it.
Yes, madam. Page
Yes.
70 of my affidavit, madam.
Page
70.
70.
Second column, my lord. Amount to be paid 50% of the wages as per the order of the Honorable High Court, dated so and so with effect from 10/7/2008 to 12/4/23. Last part, including DA increasing time to time.
No,
The DA
DA is included, but increment is not included.
and the first column on the deduction part that has already been paid, my lord. That interim order.
But that cannot be paid as per the High Court and Supreme Court judgment. I'm referring that cannot be. Because
What is the increment during this period?
Bombay High Court as well as
My lord,
Supreme
that
Court.
is not clear from this, but including DA increasing from time to time. But
DA has not-
going through the definition of gross salary, my lord, it includes the annual increment.
Wage definition, kindly, Lordship, go to the increment definition of wage.
Yes. You took it to the definition of wage and salary.
Yes, but. kindly. Deduction. Page eight in the writ petition.
You have a copy of the act, the read of the act.
Sorry, Lordship.
You have a copy of the act.
So definition I have already quoted in para 12 in page 8 of the writ petition.
Please read it.
Lordship, paragraph 12. In terms of section 2(4) of the Payment of Wage Act 1936, wage means all remuneration capable of being expressed in terms of money which would be payable to the employed person upon fulfillment of the contract, expressed or implied. It does not include traveling allowance or concession, value of house accommodation, or any other contribution paid to any pension and provident fund or gratuity payable on the termination of the employee. So this is the definition. I have quoted from this book. So here, this wage includes.
Definition availability act is slightly different.
Sorry.
You go through the act and tell us.
Yes. Section 2(4), according to payment of wages.
You're reading from payment of wages.
Payment of wages. Industrial Dispute Act also, next section B, section 2 of Industrial Dispute Act also defined wage as follows. Both the acts, Lordship. Wages I have quoted in my petition. Section 2 of the Payment of Wage Act and Section 2 Industrial Dispute Act. Here also wage means all remuneration capable of being expressed on in terms of money, which would, if the terms of employment expressed or implied were fulfilled, be payable to a workman in respect of this employment or work done in such employment experience. In both the act, the same.
Both the act, not the
Slight similar.
Not same.
No, slight similar, but definition of wage slight similar.
It will come back at
Lordship, item 15, I have shown the answer script. Lordship, meta may be taken up on the next any day, Lordship.
Can you get the increments payable to the
My
petitioner
lord,
and other?
that it is not clear from this document, my lord.
You
But
get
whether he was the tribunal or high court granted 50% back wages, but there was no direction whether to consider him on duty or qualifying survey. So he's not entitled to any increment, my lord. Otherwise, as per direction, 50% that amount has already been paid.
But if there is no direction for treating dies not, that is also there. How they have interpreted the judgment of the court and the tribunal. Whether railway officer is competent to interpret it by his own way. Kindly go through this Lordship award, page 35. Again, I am reading. Page 35 of the petition. Last paragraph of article. Labor for justice.
Award says two things.
Accordingly,
Page number 34, last paragraph you see before para 14.
Para 14 I am reading.
Above para 14.
Above 14, yes.
Last paragraph.
Yes. 34. Workman is entitled to 50% of his salary.
Salary.
No, that is the observation, discussion.
That's right.
But order is
Direction is wages.
order
Gross
is next
pay.
page. Yes. Order is next page.
Gross pay.
Yes, gross pay. So this is so gross pay, 50% of the gross pay. What is the meaning of gross pay and net pay? Gross pay including all. Moreover, when they have filed an appeal before it under 226 challenge the order in the High Court. High Court was not interested.
But there's another thing.
No.
The order passed by the management transferring you from Rongia to Murkoksal is wrongful and illegal.
Yes.
And imposition of punishment to carry out a wrongful order is not proper. So you are entitled to 50% of the gross pay with effect from the date of striking of your name. Till your reinstatement.
Reinstatement.
So there was a period which you did not work.
Yes, that is true. Because I was prevented to work.
whatever.
I am not, because that's
You-
two things. Two things.
Therefore, the labor code directed 50% of.
50%. Yeah. So that 50% I want, Lordship. I am not claiming for another thing because matter is settled already. They have come before the High Court challenging this award. That becomes final now.
Where do you say in your affidavit that it does not include treating him non-dias?
Only that part, my lord, that page 71. That memo. my lord.
71.
71. On the remarks column, my lord. 50% wages to be paid and the period to be treated as dice note.
No. Where does it say that because you have treated him non-dias, that 50% will not include the increment? This is your case?
No.
You are admitting that increments are not included.
No.
It is not included because he is treated to be non-dias.
No.
Where have you stated that?
We have not made any statement regarding that, my lord, but we have stated that whatever has been directed by this honorable court, my lord, that has been complied with regarding the 50% wages. Because the court also has not made any observation or direction to pay any increment or as such. my lord.
No. Therefore, you have to say that ordinarily it is not included. On what basis are you making this statement? So unless there is a specific direction to release the increments, you are not supposed to do so. Under what provision of law?
My lord, normally, my lord, increments are earned by rendering services, my lord. So, my lord, there is Supreme Court judgment, my lord, which says, my lord, if no service is rendered, my lord, so increments cannot be claimed, my lord. So accordingly, my lord, direction 50% that is followed and 50% that is considered as no work, no pay. Principles of no work, no pay.
Which paragraph?
Paragraph, my lord. I could not mark on it, that's got out of print out, my lord.
You mark it and give it to us.
My lord.
If you
Mark it.
Mark for it. This judgment you are referring, Delhi High Court judgment.
Lordship,
For-
judgment, there one is,
What proposition?
one is the Bombay High Court.
Yes.
Yeah.
So what proposition are you relying on this?
That paragraph 7, Lordship, kindly.
Paragraph 7 of which judgment?
Of the judgment.
Bombay judgment.
Bombay.
Yes.
in view of which I am taking is Lordship, I am reading here. The view which I am taking is also the view partly taken by the division bench of the Karnataka High Court, to which my attention has been invited by Sri Ganguly appearing on behalf of the first respondent. Indeed, it was contended before the Karnataka High Court that the word full wages plus drawn should not only include the wage drawn on the date of termination plus yearly increment, but also revision of pay, if any, affected during the pendency of the proceeding before the labor court. However, the division bench has rejected this argument and held that the word full wage last drawn would take in a total wage drawn on the date of termination plus yearly increment and dearness allowances to be worked out till the date of award, and that the same has been paid to the workman during pendency of the proceeding before the Honorable High Court. The Karnataka High Court made it clear that wage that would be worked out up to the date of award shall have to be paid during the pendency of the proceeding before the High Court. While I agree with this part of the reasoning of the learned judge, with respect, I am unable to persuade myself to agree with the view of division bench insofar as it excludes the revision of pay for being considered from the purpose of calculating the full wage last drawn. I must mention here that the figure mentioned by me, namely 2,558 as the figure full wage last drawn, is inclusive of not only the permissible allowance on the date of award, but also the revision of pay. So it includes all.
So that is not, that is in terms of the definition which is reproduced in para 5. It does not include increment.
No, but
Para 5 definition does not include increment.
full wage, but here
full wages drawn.
Yes, full wages drawn. Secondly, that here in the same judgment, it is there a 17B. It is paragraph this 17B paragraph 4. I'm reading from first page.
Okay.
Where in any case, a labor court, a tribunal or national tribunal, by its award directs reinstatement of the workman, and the employer prefers any proceeding against such award in a high court or the Supreme Court, the employer shall be liable to pay such workman during the pendency of such proceeding in the High Court or the Supreme Court, full wages last drawn by him, inclusive of maintenance allowance admissible to him under any rule, if the workman had not been employed in any establishment during such period, an affidavit by such workman has been filed in the affair, provided that where it is proved that the satisfaction of the High Court or the Supreme Court that such workman had been employed and had been receiving adequate remuneration during any such period, the court shall order that no wage shall be payable. The object of reason of introducing 17B of the Act as follows. While labor court pass award of the reinstatement, these are often contested by an employer in the Supreme Court and the High Court. It was felt that the delay in the implementation of the award caused hardship to the workmen concerned. It was therefore proposed to provide the payment of last drawn of pay of the workmen concerned under certain conditions from the date of the award till the case is finally decided in the Supreme Court or the High Court. It is clear from the reading of the provision of that, though in section 17B of the Act, your full from the date of award are not to be found, having regard to the object and reason stated for inserting this provision, one can come to the conclusion that the date from which the full wages last drawn are to be paid should be the date of award till disposal of the proceeding. So therefore, definition, the word wage has been defined in substance. Wage means all remuneration capable of being expressed in terms of money, which would, if in the terms
Mr.
of
Rahman, the paragraphs which you have read with regard to 17B is in respect of any orders passed by any court and which is challenged and is pending before a higher court.
Yeah.
Now,
so that award has been given, that order has been given in favor of me, and I am already done that payment.
Right.
But now they're trying to recover that amount. That cannot be because it is Supreme Court.
They're trying to recover.
Yes, already recovered. But we finally see their statement. That is why I am before your lordship.
Where is the recovery order?
That is the page 70. This way or that way, they are harassing me from 2008.
So where is the order of recovery?
Page 70, lordship.
70.
Yes. and first column lot. That is deducted.
Yeah.
In compliance of the Honorable High Court judgment so and so, in WPC number office order number Sabha, Kumud Chandra Kolita was allowed to resume duty, and accordingly he resumed duty on so and so. Detail of the payment history of Kumud Kolita, which was earlier shown erroneously by this order number, and the same has been now corrected as under. Already paid amount, gross amount, full wages last done as per interim order under this so and so, 27,415 to present, that is total amount 17 lakhs 23,571. Then second column, amount to be paid 50% of the wage as per the order of the Honorable High Court dated 9/2/22, with effect from 10/7/28 to 12/4/23, total 177 months, 4 days, that is 9,940, 50% of 19,000, including DA, increasing time to time. Only DA, the calculation is DA. Then difference amount to be paid, 77,400. So deduction of pay, that is 39,334. Net payable amount, 73,000. So balance there. So this is the deduction, 17 lakh. They have deducted, which I have already drawn. Whether that can be. As per the judgment of the Supreme Court, that cannot.
What is the deduction of pay on, for what ground?
Nothing. That which amount I have received and as 17B order.
So what amount has been deducted?
That is a 17 lakhs 23,571. First column statement.
This is the total amount paid.
Total amount paid is 73 lakhs 4,992 after deduction. It is a lordship case 177 months not paid. So if calculation is made 50% of the total pay of the 177, so it includes increment, yearly increment. Then again, they have treated the period, how they have interpreted all these things, I do not know, because there is nothing in the judgment, either in the High Court or the Labour Court. It is the APO, assistant person.
What is the deduction amount, Mr. Pegu, page number 70, 1, 2, 3, 4th column?
Page number 70.
70.
First column, my lord.
No,
Okay.
fourth.
Deduction of pay on CVISC and APTEC.
Amount, second amount minus first amount, that is come to third amount. Total amount they have calculated 24,978,910. Then minus this, so it comes.
No, that is in the third column.
Third
I'm
column,
asking
yes.
about the fourth column.
Fourth column, yes. Difference.
CVISC.
You get your instructions.
CVISC, Central Government Employees Group Insurance Scheme, my lord.
No, we want to know that what is the ground for refusal to grant the increment? On what basis you have placed some judgments, but para 41.
My lord.
This is on a different aspect. This does not, this is on a different aspect whether back wages should be paid or not. Back wages has been directed to be paid 50%.
My lord.
You are to satisfy us that it does not include increment. What according to you is the amount that you are supposed to receive
Lordship,
with increments?
increments per year. So,
have you calculated it somewhere?
No, sorry, I am not. In the chart only, they have in their epidemic day.
Last the era 41, my lord, last second line. In view of the same code is now England execution of the constitution for the purpose of back wages on the basis of revised scale, my lord.
No. This is on the concept of whether back wages should be granted or not. This is not an authority to say that back wages must include revised pay. This is not the issue urged here. This was one of the issues subsequently pointed out that back wages also should include revised pay. The court said that it was not pointed out before the tribunal, therefore we are not going to issue that. But the submission that he is not entitled to increment must be on some cogent material. Where are your calculations?
The chart I have not calculated as yet.
You have to show us the amount according to you, what is receivable.
Receivable amount already I have stated here, which was already received by me.
Page 70. That amount has already been paid to you.
Already paid.
Then what more?
No, that increment not calculated.
What is that amount that you want?
That I have to calculate it is.
You calculate and place it before the court.
To take time because it is a.
According to you.
For us, it is difficult for bill calculation, not. It is
Next week, my lord, I'll come out with the calculation and
expert man is required for calculation because it is, for me, it is a difficult.
No, then without knowing, how are you claiming it?
That's a no. I have annexed the chart 60, page 68. The salary difference statement. Here they have calculated only DA, grade pay. So this is the chart. Is prepared from July 2008 to 178 months. It is a preparation. So total gross pay here. This is the amount already done. This then total payable. So this is the amount. This is the chart I have submitted.
No. This
But
chart.
Here,
You
kindly.
You have received the amount.
No, kindly lordship. Look at here is just top of this remarks. Well, pay, grade pay, DA. These three items is included, but not the increment, annual increment, nothing. This clearly shows the increment is not given.
Unless
the
you come
period
up
does not, treating the period also does not. They have given a report.
You have to show us some low point on this.
No, lordship, does not. It is lot of input from the fact of the case because no, when
You are already diagnosed on because you have been granted 50%. Why will the court grant you 50%? Because you are not there.
Not there. So if
Why wasn't,
No,
why,
Lordship,
where
my
was
submission-
the
my-
occasion for
no,
the
my
labor court?
submission before Lordship, when there is a judgment of the labor court, when there is a judgment clear from the High Court also, how a railway
The
officer,
judgment is
no,
to
no,
grant you
my, no,
50%.
my question is, how
No,
a
no,
railway
kindly
officer,
listen to the court. The judgment is to grant you 50%.
50%.
They say they have granted you 50%. Your grievance is that it does not include the increments.
That one first aspect.
Then
how they have interpreted the judgment as a, is not mentioned in any of the judgment.
how does it affect you?
Does not, because if treated is 177 and does not, then I will not, the amount will be deducted.
Which amount?
Total 50% amount.
It has not been deducted, you have received it.
No, till now it is not given.
It is not given.
Not given.
Already paid.
No, not given. Payments are not made.
Their,
That's why
their
before
documents show that this is the amount payable to you. Their documents show what is your apprehension. Is your apprehension that because of the mention of the term dies non, amount which has been calculated you will be deprived of? Is that what your apprehension is?
till now it is not given because the award is a long back award. This
You have
judgment,
not given the amount, Mr. Pegu.
that's why I am before your Lordship.
No, this is page number 72 is the document, my lord, appeal.
That
If you can't get instructions, we'll have to call your officer. Who is the officer here? Who is in charge of giving all this information?
Already been paid, my lord.
See, Mr. Roman, you see your prayer at page 16.
Yes.
Kindly read your prayer at page 16.
Yes. Is to notice respondent and upon hearing the cause, would may please to direct respondent to pay the outstanding dues, plus the benefit of revised pay as per recommendation of 6th and 7th provision, increments and other benefits of dues, as he is entitled in terms of the award.
So your prayer is only for the revised benefits.
No, increment also. Increment here.
Increment and revised.
Yes. And
there is no prayer that the calculation arrived at by the respondents of the net amount payable of 7,34,000 has not been paid.
No, that is specifically that is not there. But it is there. Revise of 6, 7 is not given.
You are not answering the question of the court.
No.
If you come to page 70, there is a particular amount shown to be payable to you.
Okay.
Have you received that amount?
I have to confirm.
You have no instruction. You get your instructions.
We have already paid, my lord, that is still affidavit.
Come back with your instructions, clear instructions. Actually, it is time to expect that you will not waste the judicial time by making arguments without the basis of instructions here. We have heard you for more than an hour and now you tell us that you don't know whether the amount has been received.
No,
that much at least we can expect from a counsel of your standing. Please get the instructions. Matter was heard at some length, however. Counsel for the petition, counsel for the respondent submits that the amount shown to have been payable to the petitioner has already been released, which, however, has been disputed by the counsel for the petitioner. It is submitted that the 50% of the gross pay directed to be released by the labor court in the judgment dated so and so has not yet been released, and that apart the calculation shown to be payable to the petitioner also does not include the increments which the petitioner is entitled to be paid. Let the counsel for the parties complete their instructions from their respective clients and let the matter be listed again on.
Let it be taken Monday.
On 9th of June.
9th
of June, 6th. 6th of June.
6th of June, 7th is our in. Let it be 9th. No.
9. Then we'll have it, if you want it later, 11?
9 or 10.
11th?
11. Yes. 11, 10. 10.
11th? Yes, okay.
But 11 is holiday, I think. 11 is holiday, Lord. No. No. 11, 12.
11 June, not a holiday.
9.
11, 11.
11.
Yes. If you took your wonderful. Easy to know it. Yes.
May please, your Lordship, Mr. Pretty Datta had to leave for some urgent work, Lordship. Let the matter be listed on Monday, Lordship.
No, no.
We've gone through the answers.
Yes. We have gone through it. Anything to be submitted? What?
Lordship, as regards answer number 4, your 15 marks were there in the question paper. Only 2 marks were awarded, whereas your Lordship, it was ticked as all correct, my lord.
Correct.
Yes, Lordship, as regards question number 5, answer number 5, although it was correct, my lord, no marks were given. Only 15 marks were given in the ordered answer. And as regards item number
You
7,
bring it on affidavit.
yes,
You file an affidavit
Yes.
that in terms of the liberty granted, this was examined and
Yes.
this is what is there.
Lordship,
Bring it on record.
my
Heard MSB Mia, that's city accountant, represented by Mr. Singri, and MS Sharma.
Lordship,
was the petitioner, MS Sharma.
Name of Mr. P.P. Datta be recorded,
not
Lordship.
here.
He was here in the
But he's
morning,
not here
Lordship.
now.
Lordship, kindly his name be.
PP Dotto and MS P Sharma for APSC, MS Q Sharma for
Phone number 1.
respondent one. How much time you require?
1 week will do.
One. It's the matter again. On '28 May.
20.
Much obliged.
Oblige, your Lordship. Can it be observed, my lord?
What?
About
The
affidavit?
petitioner is permitted to file the additional affidavit as straightforward.
Prepare.
But basically, 3 issues are involved, Doctor. And the first issue is that government.
You take us through Upendas.
Yes, no, that is why I am coming to the issues, Doctor.
Right.
First issue relates to Upendas, Doctor.
Hmm.
And then the first allegation is that government did nothing for regularization of the petitioner in spite of their long services. On that point, Lordship, first I am taking to
Okay.
Umadevi, no, Upendas, Doctor.
Upendas.
Upendas is 2017 Ford GLR 493.
Yeah.
I'm coming to paragraph, Lordship, 11.
Para 11.
Yes, sir.
Okay.
In one show motor case.
Yeah.
In one show motor case being WPC taken up 24 of 2007, a division bench of this court was considering the conditions of persons prisons in the state, including engagement of adequate staff and other related issues
and by the order dated 37/2010, it directed the state government to frame policy for regularization of casual workers in terms of full bench decision in the case of Jitendra Kolika. But on 1/11/2010, when the additional advocate general informed the court about the statement made in the case of Ramani Deka regarding consideration of policy to regularize the services of master workers within 3 months, the division bench observed that no further steps need to be taken pursuant to direction issued on 37/2010. 12. On 14/12/2011, also when the case of Ramani Deka was taken up, a statement was made on behalf of the Finance Department that the matter of regularization was under active consideration. This is after 2006 law. Active consideration in coordination with the Departments of Health, PWD, Directorate of Zoology and Mining, Water Resources, etc. And the benefit of deliberations was likely to be positive in favor of the petitioners therein. However, notwithstanding the above statement made before the court, the state government filed MC number 597/2012 in WBC taken up number 24 of 2007, seeking leave to implement its policy of regularization and the division bench, having regard to the decision of the Supreme Court in Umadidi case by order dated 27/3/2012, declined to grant the leave. Immediately thereafter, the Finance Department, Government of Assam, issued office memorandum dated 16/6/2012, stating therein that there shall be no further regularization of services of master workers or similarly placed workers, even if such workers were engaged prior to 1/4/1993. The office memorandum dated 16/6/2012 was also stated that there would be no more regularization by creating supernumerary posts for 1 day in respect of those master workers who were engaged prior to 1/4/1993 but have died or had attained the age of superannuation. The Lordship, by it indicates, Lordship, even after 2005, Lordship, a policy was there for before the government, Lordship, for regularization of the workers and master employees. But in the meantime, Lordship, the decision of Uma Devi and Jiten Kalita, etc. came, Lordship, and it was the state government left with no other option but to file an application before the court seeking leave of the Honorable Court. Please allow us to go with the policy of regularization. But the Honorable Court declined to grant such leave. Thereafter, Lordship, in 2012, Lordship, by issuing this notification dated 16/6/2012, took a decision that henceforth there will be no more regularization and there will be no more creation of supernumerary posts. Lordship, this notification was challenged in the case of Upendas, Lordship, before the learned single judge. This notification of 2012, which was initially set aside by the learned single judge. Then the case, this appeal, Lordship, 45 of 2014 was initiated by the state government and the decision of the division bench before all of us. So that allegation, Lordship, that state government failed to regularize their service, it's not a correct one. Secondly, Lordship, I'm coming as regard the right of the petitioner to claim regularization. Uma Devi, Lordship.
Yes.
Uma Devi, Lordship, paragraph 49.
Yes.
It is contended that the state action in not regularizing the employees was not fair within the framework of the rule of law. The rule of law compels the state to make appointments as envisaged by the Constitution and in the manner we have indicated earlier. In most of these cases, no doubt, the employees had worked for some length of time, but this has also been brought about by the pendency of proceedings in tribunals and court initiated at the instance of the employees. Moreover, accepting an argument of this nature would mean that the state would be permitted to perpetuate an illegality in the matter of public employment, and that would be a negation of the constitutional scheme adopted by us, the people of India. It is therefore not possible to accept the argument that there must be a direction to make permanent all the persons employed on daily wages when the court is approached for relief by way of a writ. The court has necessarily to ask itself whether the person before it had any legal right to be enforced. Considered in the light of the very clear constitutional scheme, it cannot be said that the employees have been able to establish a legal right to be made permanent, even though they have never been appointed in terms of the relevant rules or in adherence of Article 14 and 16 of the Constitution. So this, Lordship, I am showing just to show that this petitioners has no right to claim regularization. Thirdly, Lordship, I am coming to the point whether a direction can be issued by this honorable court for regularization of their service, Lordship. On this point, Lordship, I am placing three judgments, Lordship. First one is Umadevi itself, Lordship, paragraph 52. Paragraph 52, madam.
Yes.
Paragraph 52.
Yes, please.
Normally, what is sought for by such temporary employees when they approach the court is the issue of a writ of mandamus directing the employer, the state, or its instrumentalities to absorb them in permanent service or to allow them to continue. In this context, the question arises whether a mandamus could be issued in favor of such persons. At this juncture, it will be proper to refer the decision of the Constitution Bench of this court in Rai Shivendra Bahadur, Dr. versus governing body of the Nalanda College. The case arose out of a refusal to promote the writ petitioner therein as a principal of the college. This court held that in order that a mandamus may issue to compel the authorities to do something, it must be shown that the statute imposes a legal duty on the authority and the aggrieved party had a legal right under the statute or rule to enforce it. This classical position continues, and a mandamus could not be issued in favor of the employees, directing the government to make them permanent, since the employees cannot show that they have an enforceable right, legal right to be permanently absorbed, or that the state has a legal duty to make them permanent. So this is one paragraph, Lordship. Next paragraph, Lordship, I am reading from 2007 10 SCC 544. Paragraph 7, Lordship. 2007 10 FCC 544. Paragraph 7.
Yes.
Paragraph 7. We are of the opinion that in view of the Constitution Bench judgment of this court in Secretary State of Karnataka versus Umadevi, this court cannot direct regularization in service. Since the court has no power to direct regularization, it also follows that it has no power to direct grant of benefits payable to the regular employees. This is Supreme Court, Lordship. Third judgment, Lordship, I am taking 2008 10 SCC 1.
2000,
2008 10 SCC 1.
official liquidation.
Yes.
Yes, paragraph.
Paragraph 71. 71.
Yes.
Paragraph 71 is page 46.
Yes. Yes.
In state of Karnataka versus Umadevi, the constitution bench again considered the question whether the state can frame scheme for regularization of the services of ad hoc temporary daily wager appointed in violation of the doctrine of equality, or the one appointed with a clear stipulation that such appointment will not confer any right on the appointee to seek regularization or absorption in the regular cadre, and whether the court can issue mandamus or regularization or absorption of such appointee, and answered the same in negative. So by placing this state judgment, Lordship, what I am trying to emphasize, Lordship, this court, hands of this courts are bound by this judgment not to grant any direction, not to grant any relief by directing the authority to regularize the service of the master and work as employees. Lordship, one more point was made, Lordship, that after Umadevi Lordship, of recently Lordship, there is a shift in the legal position, Lordship, vis-a-vis the directions made in the Umadevi judgment. And to reflect that, the Prem Singh judgment was placed. Prem Singh, I have already tried to distinguish by showing that even in Prem Singh Lordship, paragraph 33, a specific line was there that even paragraph 36, Lordship. In that case, Lordship, even after having a government instruction, and even as per decision of this court, state of Karnataka versus Umadevi, those petitioners were not regularized. That is why a direction was, specific direction was passed, Lordship, in specific of that particular case, Lordship. So this judgment cannot be applied everywhere, Lord. That is my understanding. And secondly, Lordship, this judgment was subsequently clarified by another Supreme Court judgment, Lordship, and that is Uday Pratap Thakur versus Uday Pratap Thakur and another versus State of Bihar law. 2023 SCC online. Yeah. Yeah. Yeah.
Yes.
In my copy, Lordship, this is paragraph 6.3.
Yes.
Now in so far as 6.3, Lordship.
Yes.
Now, insofar as the reliance placed upon the decision of this court in the case of Prem Singh by the learned counsel appearing on behalf of the appellants is concerned, the reliance placed upon the state decision is absolutely mistaken. In the state case, this court was considering the validity of Rule 3A of the UP Retirement Benefits Rule 1961, under which the entire service rendered as workers was not to be counted for qualifying service for pension. To that, this court has observed and held that after rendering service as workers for number of years in the government establishment, department denying them the pension on the ground that they have not completed the qualifying service for pension would be unjust, arbitrary and illegal. Therefore, this court has observed and held that their services rendered as workers shall be considered counted for qualifying service. This court has not observed and held that the entire service rendered as workers shall be considered counted for the quantum of pension. The decision of this court in the case of Prem Singh, therefore, would be restricted to the counting of service rendered as workers for qualifying service for pension. So this is the distinguishing part of it. It is limited to that on that issue only. To that issue only, Lordship, whether the period before regularization should be counted for the purpose of counting qualifying period or not. That was the only issue as has been held by the Supreme Court in this case.
Good.
Lordship, this judgment was placed before a learned single judge in WPC number 1177 of 2017. Lordship. 1177 2017. That is Srimati Gita Burman versus State of Assam and others, 6 others. Paragraph 14, Lord.
Is that Gita Parma?
Paragraph 14, Lordship. The Honorable Supreme Court in the case of State of Nagaland, Supra, has also interfered with the action for effecting one-day regularization. Para 14, Lord.
14.
1-4.
Yes.
As observed above, the direction made in the case of Prem Singh has been held to be confined to the fact of the case as observed by the Honorable Supreme Court in the subsequent decision of Uday Pratap Thakur.
Yes.
So I'm again referring to paragraph 36, Dr. Umadi Law.
Paragraph?
I mean, Prem Singh Law. Paragraph 36.
36.
Paragraph, that same paragraph. Page 541.
Yes.
Paragraph 36, Lordship, last line, this court. This is in reference of Umadi Law. This court in the said decision has laid down that in case services have been rendered for more than 10 years without the cover of the court order, as one-time measure, the services deregularize of such employee. In my humble understanding, Lordship, this is completely good. One more condition is there. This is here, Lordship, only two conditions have been mentioned: 10 years and without cover of the court order. If Lordship comes to paragraph 53, Lordship, of Uma Devi, one more condition is there, Lordship, that is holding a substantive court order. Lordship, in a subsequent judgment, Lordship, that came in 2023, that is 2023, 3 STC 639. Two thousand 23, 3 STC.
Yes. Yes.
Paragraph 4, Lordship.
Para 4.
Para 4, Lordship. The learned single judge, while allowing the writ petition, gave direction for regularization of the appellant from the date on which he is junior to a regular. This order was challenged by the state government before a division bench, which allowed the appeal of the state government. The division bench rightly held that the learned single judge had not followed the principle of law as given by this court in state of Karnataka versus Uma Devi, as initial appointment must be done by the competent authority and there must be a sanction force on which the daily rated employee must be working. These two conditions were clearly missing in the case of the present appellant. These two conditions were clearly missing in the case of the present appellant. The division bench of the High Court therefore has to our mind rightly allowed the appeal and set aside the order dated 27/6/2019. So this only indicates that all the three conditions of Uma Devi has to be fulfilled. Only then somebody can be considered for regularization.
Yeah.
Then Lordship, third point was raised by the petitioner's Lordship, referring to that notification of 1996 and 2003, that even if their services has not been regularized, they are entitled to pension because of that notification of 2003. Paragraph 50, page 55 of the rate petition.
Yeah.
So Lordship, may kindly see the subject. Pensionary benefits to the state government pensioners, family pension holder. In the Government of Assam circular issued under Office Memorandum number so and so dated 10/8/63 of Finance Department, a temporary government employee, Lordship, may kindly note this word government employee, who retires after rendering temporary service of not less than 20 years under the government without being confirmed in any post is to be allowed the pensionary benefit as available to a retiring confirmed government employee, either on attaining the age of superannuation or on his being declared to be permanently incapacitated for further government service by the appropriate medical authority. The said OM came into force with effect from 1st of September 1982. The Governor of Assam is now pleased to clarify that all temporary government employees who have retired from the service under the Governor of Assam, fulfilling the criteria of not less than 20 years of continuous service, will be eligible for pension from 1st of September 1982 onward. This is, however, subject to condition that they satisfy all conditions other than the condition of permanency against permanent post under the Government of Assam for usual pensioner benefit under the Assam Services Pension Rule 1969. This benefit not admissible to any retiree who retired from service with retirement benefit under CFCP approved. Now, Lordship, may kindly see the last but one line. Subject to usual prisoner benefit under the permanent post under the Government of Assam for usual pensioner benefit under the Assam Government Pension Service Rule 1969. So this refers to Rule 31 of the Assam Pension Rules 1969. If Lordship comes to the next page, that is the clarification, Lordship, at page 57.
Yes.
In continuation of this department's OM number so and so 12/9/1993, it is reiterated that the said OM clearly lays down that a state government servant rendering 20 years of continuous service without being confirmed shall be eligible for pensionary benefit. The focus is on 20 years of continuous service. Lordship, first condition, Lordship, he has to be a government employee, and second is continuous service of 20 years. Shall be eligible for pensionary benefit. The focus is on 20 years of continuous service. After rendering 20 years of service, if the government servant is superannuated or incapacitated or dead, is not root point. Any confusion in this regard is against the spirit of the OM, therefore to above. It is therefore clarified that pensionary benefits as contemplated in above OM shall be admissible to a government servant who died after rendering 20 years of continuous service. Other terms and conditions of eligibility of pension then remain the same and as usual. So the basic thrust of these two notifications, Lordship, Office Memorandum, is that so that 20 years period is okay, but before that, Lordship, first condition is you have to be a regular, government servant holding temporary post. Now the distinction of temporary post and substantive post, Lordship, I have elaborated on the last day also. Lordship, one notification, Lordship, I would like to say. Now, Lord, this is the letter dated, Lordship, 22nd of August 2025. Now, this is the direction, Lordship, by which, Lordship, in the year 2025, government decided to regularize services of around 30,000 master and work charge employees. And In that notification, Lordship, if Lordship comes to,
But this is not a part of the pleading.
not part of. So I am just only trying to give an example who are temporary employees. This is common to all regularized employees were regularized by this notification only. But if Lordship comes to page 11, Lordship, internal page is 3, third page.
Yes.
Serial number 5, Lordship. These posts are personal to respective works as master roll worker and will be abolished as soon as the incumbent relinquish the post in any manner. So these are temporary posts. Lordship. These posts were created, temporary posts were created under the government, and these petitioners, Lordship, were given the benefit of this notification of 1996 and 2003. So if the person, master roll worker or workers employee, either regularized in the year 1995 or in the year 2005, Lordship, they are entitled to pension if they continue 20 years of service under the notification of that 1996 and 2003. So to avail the benefits under those two notifications, Lordship, the necessary condition is that their services has to be regularized. Then next time, Lordship, referring to another judgment, Lordship, this is WA 1 of 2022.
Is it a part of your compilation?
Yes, Lordship, it was furnished on the last day.
Read appeal.
Read appeal WA 1 of 2022.
Yes. It's not here, but you give us the citation WA. Read appeal.
Read appeal 1 of 2022. Paragraph 21. Lordship, this is a case, Lordship, where the wife came before the Honorable Court, Lordship, paying for family pension in respect of her husband's service, Lordship, whose service was never regularized. Paragraph 21. Rule 31 of the Assam Services Pension Rule 1969 provides for condition of qualifying service for pension and which as under 31. The service of an officer does not qualify for pension unless it conforms to the following three conditions. First, the service must be under the government. Secondly, the employment must be substantive and permanent. Three, service must be paid by the government, provided that the governor may, even though either or both the conditions 1 and 2 above are not fulfilled, declare that any specific kind of service rendered in a non-gazetted capacity shall qualify for pension. And in individual cases and subject to such conditions as he may think fit to impose, in each case, allow service rendered by any officer to count for pension. 22. The said rule clearly provides that service of an officer does not qualify for pension unless it conforms to the three conditions, namely the service must be under the government, the employment must be substantive and permanent, and the service must be paid by the government. Rule 36 of the Assam Service Pension Rule provides that service does not qualify unless the officer holds a substantive office on a permanent establishment, provided that continuous temporary or officiating service under the government of Assam followed without interruption by confirmation in the same or any other post shall count in full as qualifying service, except in respect of a period of temporary or officiating service in non-pensionable establishment and B, periods of service paid from contingents. In view of the above position of law and the decision of the Honorable Apex Court rendered in ML Keteri, we are of the view that the appellant writ petitioners are not entitled to pension or any relief as claimed in the writ petition, and no interference is called for in the impugned order dated 24/11/2021, passed by the learned single judge in WPC number so and so, and the order dated so and so, passed by the learned single judge in WPC number so and so. Same case, Lordship, there also it was a worker that. So basically, these are my citations, Lordship, and on the basis of these citations, Lordship, I would like to pray your Lordship not to allow this petition by passing any direction, or either for their regularization or for granting them pensionary benefit.
Yeah. You like to do it today or?
If you're not to do, otherwise.
No, that's all right. No, because he's faced some judgments. I don't know whether you have access to those.
May I please? Lord, I was conscious of Uma Devi. And I am also conscious the changes that have been made about by the Supreme Court subsequent judgment on Uma Devi. So the evolution of that change is what I tried to place before your Lordship in my opening.
Yeah.
The petition before your Lordship, there are certain admitted facts. It is admitted that they were appointed by the government. The appointment letters is connected. They have been given a scale, and we have shown from the service record the usual increments every year have been given to them. Their services were utilized not in a work charge project. It is a temporary appointment with a scale. The concept of workshop, as your work charge, your Lordship
that the last time indicated yourself, in the sense that it is charged to do work. Work is ended, their service goes on. It is not this. This is a continuous service from the date of the appointment till we receive the letter of superannuation. It is continuous. There is no break. And you are getting a scale, and you are getting the normal increments, which are all associated with the hallmarks of a normal government employee. It is that kind of a factual situation which is there in the writ petition. It is on that basis we are saying that you have taken our service for all these years, and finally your letter of superannuation has come. This entire history is symbolic of any regular employee under the government. You have given everything else, and you say that only pension is not payable. And the issue here is not regularization. Issue here is he has already served his period. Whatever level one puts, the fact remains that they were appointed by the government, they were given a scale, they were getting the normal increments and all other allowances. Therefore, the treatment which they was given is that of a regular, normal government employee. Therefore, when you superannuate him by a notice, do you get the pension or not is the short question before law.
Yeah.
Now, that is not dealt with by Umadevi. Therefore, Milord, this emphasis on Umalevi is misplaced in the facts of this present case. And therefore, our prayer in the writ is that you should declare that they have been deemed to be a regular employee. Why? Because of the facts we have alleged and shown that whatever has been done it only leaves an impression of a person who is a regular government servant. So having done all which you normally would do to a government servant, at the end, at the fag end, you can't say that he is not entitled to that. That's the short quick. Umadevi doesn't give that answer.
Yes.
This issue was not there in Umadevi. Therefore, the subsequent judgments which have explained Umadevi is important. As your Lordship mentioned on the last occasion, it's a law is an evolution. It doesn't stay still at one point. Umadevi, the courts have indicated the basic purpose was twofold. That this illegal process of appointment should go, and if you have served for 10 years, you should get a benefit in spite of that being an irregularity. These are the two I'll again place those judgments. That is the crux. That's how Uma Devi has been explained. Therefore, this development which has taken place is something post Uma Devi. They were aware of the Uma Devi in Prem Singh. They have indicated why they are saying that even if they are not regularized, you have to give the pension. Uday Pratap relied on has been explained subsequently. And Supreme Court said that that judgment has not been correctly decided as far as the implication of Prem Singh is concerned. So Uday Pratap Thakur has been explained in that 24 judgment, 25 judgment. I placed that 4. So this Uma Devi has aged. She has served her purpose, but law has not stood still. Time has gone, flown, different problems have arisen, and different claims came from government servants, and those were dealt with by some of these judgments, which therefore explain Uma Devi by saying that Uma Devi is not a shield for your exploitation of your employee. Prem Singh dealt with 2 categories. One who were regularized, the other who were not regular. The importance of Prem Singh is that those who are not regularized, even them, you can't discriminate. Uma Devi is not an answer for that. The notifications which have been issued, which are annexed to the page 55 and page 57. One in 96, the other is 2003.
'96.
Yes.
56.
Page 55 first, 96. Yes. If I may just refresh below. Huh? Yes, page 55 of the read. 12 September 1996. In the Government of Assam circular issued on 10/8/63, in the Government of Assam circular issued under the office memorandum dated 10/8/63, a temporary government employee who retires after rendering temporary service of not less than 20 years under the government without being confirmed in any post is to be allowed the pensionary benefits as available to a retiring confirmed government employee either on attaining the age of superannuation or on his being declared to be permanently incapacitated for further government service by appropriate medical authority. The said OM came into force with effect from 1/9/82.
This office memorandum,
Yes, please.
the emphasis perhaps cannot be only on the word temporary. It must be read to be temporary government employees.
Correct.
Only temporary perhaps will not
No,
be a correct.
we are really dealing with government employees.
Right. You claim for the petitioners to be treated to be government employees.
Yeah,
As on date, they are not government employees.
they have superannuation.
No, even assuming they are
Kindly see the appointment.
regular scale.
No, kindly see the appointment. Page 25. The original letter is at page 25, typed
Yes.
letter, and we are giving a better. In the interest of public service, Pramod Kakati, Assam is hereby appointed as work charge section assistant in the scale of pay of so much plus other allowances as admissible under rule in Boko Road subdivision. The appointment is purely temporary and may be terminated any time without notice. If it is not government notice, below what?
No, for this appointment to be government, there has to be a procedure followed by the government.
We have said that they have not denied. Let me put it that way.
Right.
Para 5.
Yes.
Page 10. That being duly qualified to hold the post of grade 3 and grade 4, the petitioners, as has been stated herein above, were appointed as work charge sectional assistant under Public Works Department on various dates. It will be relevant to state herein that the recruitment of the petitioners was as per the prevailing procedure, and in fact there was no other method of recruitment which was followed by PWD at the relevant point of time when the petitioners were appointed. Pursuant to their engagement, the petitioners have duly discharged the duties allotted to them from time to time without any break and without any blemish, and to the satisfaction of all concerned till the date of their superannuation. For the sake of brevity and for easy reference, the dates of appointment and superannuations are given here. All these petitioners we have given. Now this is
Where is your order for superannuation? Is there any communication? Superannuation?
Yes. We have annexed the that is at page middle. I'll give you a lot tip. The retirement is at page 48. You've given the one position 48. This is for petitioner number 3.
Yes.
Kulin Bihari Oza, Workshare Section Assistant of PWD Guwahati, East Road Subdivision under this division is hereby released from the government services with effect from 31/3/19 on attaining the age of superannuation.
Yes.
And the averments, which I just read out at page paragraph 5, that is being dealt with in the government's affidavit in para 6 at page 63. This is the affidavit figure. Page 6.
Is it covered by a set of rules showing the cadre of work charge or?
They said that they were eligible for grade 3 and 4. That's about it. Now, kindly see the reply at page para 63, Miller. Para 6.
Yes.
That as regards the statements made in paragraph 5 of the writ petition, the deponent humbly begs to submit that all the petitioners at serial 1 to 6 were engaged as work charge section assistants under the erstwhile Guwahati Road Division after 1493. The government of Assam never took any decision to regularize the services of any work charge personnel engaged subsequent to 31-3-93. Since the petitioners were engaged after 1493, their services could not be regularized as per policy of the government. The basic facts that they were appointed is not denied. We replied to this also in para 69, page 69, para 6. Para 69 at page 6, we have replied. Just to complete the narration. It starts at 6, page 69. I am reading from para 70, or page 70. Page 70 top. It's a continuation of para 6. It's the affidavit in reply of
What are the parameters or the characteristics of a government servant, master servant relationship?
Correct.
Essential.
Absolutely.
So, admittedly, these posts are not covered by the cadre, etc., not reflected in the rules.
There was no rule as such. They are temporary government employees.
They are temporary employees, there is no dispute on that.
Right.
They have rendered services, no dispute
No
on that.
dispute on that.
Their office, what do you say, the service book and regular salary, everything they have got.
Everything.
Perhaps they may have also got increments, I do not know.
Increment every year.
Every year. But what are the traits to say that an employment is a government employee?
With an appointment letter of this type,
No, but
with a superannuation letter
this, no,
coming at the end of it.
appointment letters, yes,
Yes.
but, uh,
The
is it
service
enough
book,
to say
the
that?
service book, Milord, which I placed before your lordship. Every entry is of the increments, everything is noted there. What more do you want? And in the retirement, it is mentioned. Kindly see the retirement notice. Page 48. So and so is hereby released from government services. Government services, it is sent by the executive engineer, copied to Accountant General Assam, Chief Engineer, everyone. Office order of book of record.
Yeah.
That's why it was a surprising argument to hear that the petitioners are not government servants. They are given scale pay, therefore it is budgeted. Sanctioned about it. Otherwise, how will they pay? And they themselves say it is government service.
Yes.
So that there is nowhere even pleaded in the affidavit. Release from the government. I was at page 70.
Yes.
First line at the top. In fact, it is the categorical and specific case of the petitioners in the writ petition that as they were duly qualified to hold the post of grade 3 and 4, they were appointed as Warwickshire Section Assistant under the PWD department, and their appointment were as per the then prevailing procedure, and at that point of time there was no other method of recruitment which has been followed. It may also be relevant to state herein that there is no denial to the said fact by the respondent in the paragraph under reply. Moreover, as has been stated here above, on account of non-regularization of their service, the petitioners are seeking pension on the strength of the aforesaid office memorandum dated 12/9/96 and 6/9/2003, which are still holding the force, which are still holding force on the, as on date. This is an admitted position, my lord. There is no difficulty on that. And that is where the distinction comes, with the cases of normal regularization cases which Uma Devi dealt with. And did the Uma Devi case say you were not regularly appointed, your appointment was illegal, therefore forget everything? It says that if you have served for 10 years without court's intervention, you have to be regularized. And that's how subsequent decisions have explained the Uma Devi case. It doesn't say that you should be thrown out. They say if you have served the government for 10 years, you need to be regularized. And that one-time exercise in two subsequent decisions came to be explained. One from Justice Lokur's judgment and another from Justice Chandrasud's judgment. 110 doesn't mean that you, at one point of time, you take up the case of some people and leave it. It says that all who are eligible to be regularized, they should be considered. You can't make a discrimination there. But we are not concerned with that stage now. You have taken my full length of service. Without any blemish, I have done everything. And you have said that you are superannuated, therefore, the letter. Therefore, the only question is, here it is not regularization, it's a question of whether I am entitled to the pension. If I have served all these years, if you have treated me as a regular employee by all of your actions, which only can give that impression of a cumulative fact impression, is that something which is done to a regular employee, you have done the same thing to me. And you are now saying, accept everything, but you can't get paid. So what is the logic? Your lordships have held that pension is not a bounty. It's a right, a property, fundamental right. Since 1971, that has been the view. Therefore, question here is not regularization. I have served my period, reached the age of superannuation, you have retired me. Question is, am I or am I not entitled to pension? I am entitled to pension on the basis of your two poems, apart from anything else. Temporary government employee who retires after rendering temporary service of not less than 20 years under the government without being confirmed in any post is to be allowed the pensionary benefit. That's page 55.
Yes, that is for temporary employment.
57, 2003
What do you
notification.
say about the division bench and judgment and the coordinate bench judgment?
Because the problem with the division bench judgment is this. They were dealing with all cases of regularity. I have passed that age or stage. You have continued it till the end of a government servant's journey, namely the date of superannuation. So the question here is different. If you have treated me as having retired from the government service, as you very specifically mentioned in the letter of superannuation, do you give me pension or not? If not, why not?
But your earlier arguments was on the basis of Premsi concept.
That's why I say
That it's
Premsing is
deeming-
a development.
It's a deeming regularization.
Correct. What else will you say to a government servant who is given all this, an appointment letter, whose service record book is open, he is given every year an increment and a scale right from the beginning, and then a superannuation notice from government service. How else would you interpret this situation? This was never an issue in any of these cases. This claim for pension arose in Prem Singh. Otherwise, every case was a case of for regularization. That means they were still in service. It is post-retirement case. That's the difference here. Your entire set of orders and the way you have dealt with this category of employees before your lordship, that creates that impression that it is as if they are regular employees. Whether you will regularize it or not is immaterial. And their notification says the crux of the matter is whether you have served for 20 years. That is the second notification. It clarifies to that extent. Page 57. In continuation of the earlier 96 notification, it is reiterated that the OM clearly lays down that a government servant rendering 20 years of continuous service without being confirmed shall be eligible for pensionary benefit. The focus is on 20 years of continuous service. After ending 20 years of service, if the government servant is superannuated, the other incapacitated or dead is not the root point. Any confusion in this regard is against the spirit of the OM referred to above. It is therefore clarified that the pensionary benefit as contemplated in the above notification, OM, shall be admissible to a government servant who died after rendering 20 years of continuous service. Other terms of and conditions of eligibility of pension shall remain.
What was clarified in Uday Pratap? Uday Pratap.
Let us see Uday Pratap. And I will place below the other judgment of 25.
6.3.
They were dealing with service pilot of government servants who were regularized during the currency of their service. And the issue was different, whether the entire period of service will be counted or the service post-regularization will be counted. That is what was the issue there. Now, Uday Singh has been explained in 2025 SCC online SC 385. We have given that. I have given that to you.
Yes, we have.
Yes. This is State of Odisha versus Sudhanshu Shekhar Jena. And in para 13, page 31, it is clearly said that Uday Singh was not correctly decided. Kindly turn to page 31, Milot, and para 30. After discussing all cases below, Uday Pratap was quoted in paragraph 12 extensively. Para 13. In our respectful opinion, the above interpretation by the two-judge bench of this court regarding the three-judge bench decision in Prem Singh does not appear to be correct, as the three-judge bench has been quite unambiguous in asserting that the entire period of service of the work charge employees has to be counted for pension. An issue which is not relevant for our purpose so far as the qualifying service period is concerned, because our notifications clearly indicate that it was 20 years is the yardstick, and all of these people have served for 20 years. All the petitioners before. That apart, but the ratio of Uday Singh as a judgment has been held by actually this bench that it is not correctly decided, and therefore, in my most humble and respectful submission, it will not be possible for a high court to rely on Uday Singh as far as the implication of the Prem Singh case is concerned. On the issue which is really not relevant for our purpose, what is the qualifying period of service, was the issue where there was that difference. Here there is no
It is only on, it is only in respect to that aspect.
Yes.
Which was examined on.
Yes.
In Prem Singh.
Yes.
That
Prem Singh,
further observation was there that in respect of those who have not been regularized will follow.
yeah, and entire service period.
The question of whether those regularized
Yeah.
otherwise can be deemed to be in government service or not was not a question answered.
No. No, not
There is
even
no
in
finding on
Uday Singh, nor even in Prem Singh, because the whole question was relating to pension. Right to have the pension was the issue. And Prem Singh is important because it said, I'll place
This observation of Prem Singh at para 36
right,
is,
absolutely.
is preceded by the observation of the apex court in the said judgment,
Yeah.
where it has read down provisions of that rule.
Rule 3A.
It has read down.
Absolutely. Prem Singh is really the case which is akin to our case. And in fact, that is the first case which is giving an indication of at page 30, page 540. This is a very crucial paragraph. We are in para 29, my lord, your lordship will find the arguments set out on behalf of the government.
You're reading Prem Singh.
Yes. 2019, 10 SCC 516.
Okay. Para?
Para 29, the submission of the state of UP has been set out. Then para 30, my lord, I am relying on 540. We are not impressed by the aforesaid submission. The appointment of the work charge employee in question had been made on monthly salary, and they were required to cross the efficiency bar also. How their services are qualitatively different from regular employees. This is the issue in our case, below. No material indicating qualitative difference has been pointed out except making bold statements. Here, even that aspect, I have shown that it is admitted, what we have said. The appointment was not made for a particular project, which is the basic concept of the work charge employee. Rather, the very concept of work charge employment has been misused by offering the employment on exploitative terms of the work which is regular and perennial in nature. The work charge employees had been subjected to transfer from one place to another like regular employees as apparent from documents placed on record. In Narayan Dutt versus so the appellants were allowed to cross efficiency bar after 8 years of continuous service, even during the period of work charge services. Narayan Datta Sharma, the appellant, was appointed as a work charge employee as General Mapak with effect from so. Payment used to be made monthly, but the appointment was made in the pay scale of 200 to 320. Initially, he was appointed in the year 78 on a fixed monthly salary of 2005 per month. They were allowed to cross efficiency bar also as the benefit of pay scale was granted to them during the period they served as work charge employees. They served for 3 to 4 decades, and later on services have been regularized time to time by different orders. However, the services of some of the appellants in few petitions and appeals have not been regularized even though they had served for several decades and ultimately reached the age of superannuation. It fits in with our case, identical. In the aforesaid facts and circumstances, it was unfair on the part of the state government and its officials to take work from the employees on a work charge basis. They ought to have resorted to an appointment on regular basis. The taking of work on the work charge basis for long amounts to adopting the exploitative device. Later on, though their services have been regularized, however, the period spent by them in work charge establishment has not been counted towards qualifying service. So this is an issue which was decided where below the that Uday Singh said something and which the letter has been said that they have not correctly interpreted Prem Singh. That issue is not relevant for our purpose. Our purpose, the earlier facts are absolutely identical. In fact, ours is better because the appointment letter gives the message that it is a government appointment and which is supplemented by the superannuation letter which says you are retired from government service. So 31 I have just read out. Then, my lord, the state has been benefited by their services rendered by them in the heydays of their life on less salary in work charge establishment. In view of the note appended to so-and-so, there is a provision to count service spent on work charge contingencies or non-permissible pensionable service in a case a person has rendered such service in a given between the period of two temporary appointments. That rule was 3.8. We have no such rule and no such issue here. So that was held to be not correct. Therefore, they have read down that 3.8 and said that the entire period of qualifying service will be the service for the purpose of pension. That's the difference subsequently with Uday Pratap and finally decided by the other Odisha case. Now kindly turn to and a few lines from para 33 at page 541, Milord, about 6 lines from the end of that paragraph, 33. Service of workshops periods remains the same for all the employees once it is counted for one class. It has to be counted for all to prevent discrimination. The classification cannot be done on the irrational basis, and when the respondents are themselves counting periods spent in such service, it would be highly discriminatory not to count the service on the basis of flimsy classification. The rider put on the work charge service should have been preceded by temporary capacity is discriminatory and irrational and creates an impersonal classification. That is there that creates thing, they said that it is bad. Then, Milord, 36. There are some of the employees who have not been regularized. In spite of having rendered services for 30, 40 years or more years, and whereas they have been superannuated, just like our case, Milord. As they have worked in the work charge establishment, Milord, your lordship kindly make a little note. You are appointed as a section officer in the work charge branch of PWD. Here also the same thing. As they have worked in the work charge establishment not against any particular project, their services ought to have been regularized under the government instructions and even as per the decision of this court in state of Karnataka versus Uma Devi. This court in the said decision has laid down that in cases service has been rendered for more than 10 years without the cover of the court's order as one-time measure, the services be regularized for such employees. In the facts of the case, those employees who have worked for 10 years or more should have been regularized. So after Uma Devi, if you say that they were not regularized, it was your duty to have started a process to regularize them if you are relying on Uma Devi. It would not be proper to regulate them for consideration of regularization as others have been regularized. We direct that their services be treated as a regular one. That's the direction for the purpose of pension. However, it is made clear that they shall not be entitled to claim any dues of difference in wages had they been continued in service regularly before attaining the age of superannuation. They shall be entitled to receive the pension as if they have been retired from regular establishment and the services rendered by them right from the day they entered the work charge establishment shall be counted as qualifying service for the purpose of pension. So this part, my lord, as far as the qualifying service is concerned, it was given for the entire period. And that was the subject matter of difference between the Uday Pratap Singh's case and that Odisha case. And the latter judgment said that they have not correctly interpreted Prem Singh when they said that the entire period will not be counted, because it is emphatically said that it will be counted. But that is irrelevant for our purpose. The relevant part is only that is with regard to qualifying service. There is no dispute with regard to our case, Milord, because they have all satisfied that qualifying service. In view of reading down the rule, they had a rule, we don't have that rule, but having read down, they say, we hold that the services rendered in the work charge establishment shall be treated as qualifying service. Under the aforesaid rule for grant of pension, the arrears of pension shall be confined to 3 years only before the date of the order. Let the admissible benefits be paid accordingly within 3 months, resultantly appeals are allowed. So, Prem Singh is, Milord, basically, the issue was that even if you are not regularized, but you have all the marks of a regular employee and you have served the entire period, would you get pension or not? They said, yes, you will get pension. And therefore, the direction was given that treat them as regular to get the pension. That is why, Milord, this judgment is applicable to our case and not the others. Because I am not asking for a mere regularization. I have been served, I have served through till the date of superannuation. So it doesn't conform to the other cases below. Only question is now, with these facts, will you treat them as a regular employee and hold that they have satisfied the yardstick of a 20-year service as notified? If so, they will be entitled. And that is what Prem Singh has said. And subsequent case, as I have already placed before your Lordship, 25, Division Bench has categorically said that Uday Singh was not, Uday Pratap was not correctly decided so far as that qualifying service part is concerned. But if you have treated the person the way they have gone through, which is not in dispute, which is an admitted position, they have all the marks of a regular employee. And that's what Prem Singh says. They had all the marks of a regular employee. You don't call them regular. That doesn't take away the rights. You better call. That's why the direction, direct. They will get the pension. There is a case where people have come after they are superannuated. All these cases, other cases are basically concerning people who are seeking regularization, and the Umadevi, how far it is applicable and all that is mentioned. But this one-time exercise, there are two decisions. The first is of Justice Lokur and Deepak Gupta Milot, this is 2018, 8 SCC 238. And the relevant paragraph is 8 and page 7 and 8 at page 241 and 242.
You have not furnished this.
Oh,
You have copies?
Oh, I'm sorry. Second to the I'm sorry. It's on the two learn. There are two judgments on that. That's why we have given two. First is 2018 8 SCC 238 Miller. One time, what does it mean? Uma Devi is explained. Para 8 242. In para 7 Milot at page 241. The purpose and intent of the decision in Uma Devi was therefore twofold, namely to prevent irregular, illegal appointments in the future, and secondly to confer a benefit on those who had been irregularly appointed in the past. So one is for the future, and the other is for those who have already suffered that situation, but a way out has been given in for those supposedly irregular appointments.
But in your case, there's no question of irregular.
No, that's why I'm saying Uma Devi doesn't apply to us. You have appointed us in the way you have been appointing these people in the same way, which you have not disputed. We have said that. And that is the other one is Justice Chandrachud, Vidyanwas and Hemant Gupta, Union of 2019 4 SCC 290. Para 21 to 24 at page 299. And Milot at page 298, paragraph 21, they have quoted the Justice Lokur's case, which I have just placed. And then, Milot, if your lordship kindly turn over to page 299. Para 24, according to direct, the case for regulation shall be considered strictly in accordance with the seniority list in pursuance of the directions which were issued by the tribunal and confirmed by the High Court, and such of the persons who are available for regularization on the basis of vacancies present at present shall be considered in accordance with law. The tribunal has denied back wages, but has ordered a notional fixation of pay and allowances. While affirming that decision, we direct that persons who have crossed the age of superannuation will be entitled to the computation and payment of the retired dues on that. So this was also people of mixed variety. But what is one time? The argument earlier was that if they have done it once, it is over. They said no. Whoever has completed those 10 years form a class. So it doesn't mean that you have exhausted by one-time exercise. Those who are there, you can't discriminate. You have to. That is not an issue for us here. So this is the situation, my lord. As far as Uma Devi is concerned, my lord, that was an important judgment because if your lordships will recall the bar days, the appointment of illegal appointments or irregular appointments were passed. And that's why something had to be done, and therefore the Uma Devi case came and saying that you can't go on with this, except those who have served for 10 years, that irregular part has been taken care of by a process of regulation. Otherwise, my lord, the issue which we are concerned with was not an issue for Uma Devi. Therefore, Uma Devi is irrelevant as far as our issue is concerned. Our issue is, below, the people have already served. You have taken their service. And question is now whether they come, when they come for pension, whether you will give them on. That is a new aspect which has been dealt with by Prem Singh. And that is in our favor because it says that if you have worked for so long, then you can't be exploited by denial of pension. You have to give them. That's the difference between the Uma Devi and Prem Singh. Uma Devi dealt with an issue which was very vital at that point of time. Once that is over, then, my lord, the question of pension comes after he reaches superannuation and he is superannuated. And then, my lord, the notifications come so far Assam is concerned because there is no specific rule as such for those. And it says that your yardstick is, the route is 20 years of service. You may not be confirmed. It may be temporary service.
There is another hurdle for you, if I may say.
Yes, yes, please, my lord.
This is this judgment rendered by division bench of this court.
Correct.
Which is referred to by the respondent.
Yes.
Where the provisions of the pension rules are referred.
Correct.
Say that you must satisfy the.
My lord, let us see that conditions for a moment. Rule 31. Of 69 rule. The service of an officer doesn't qualify for pension unless it conforms to the following three conditions. Rule 31. my lord.
Yes. Yes.
The service of an officer doesn't qualify for pension unless it conforms to the following three conditions. First, the service must be under government. I don't think, my lord, there can be any doubt about that. They were appointed by the government, they were served under the government, they have been superannuated by the government, and it is specifically.
Perhaps first and third condition you satisfy.
Yes, the second condition, employment must be substantive and permanent. Even if you are not permanent or confirmed, our notification said, if you have served for 20 years, you will get it. That is the second one. Third one, again, service must be paid by government. That I have satisfied. The second one, your lordship is mentioning, the employment must be substantive and permanent.
So therefore,
And kindly see, provided that the governor may, even though either or both of the conditions 1 and 2 above are not fulfilled, declare that any specified kind of service rendered in a non-gazetted capacity shall qualify for pension. And in individual cases and subject to such conditions as he may think fit to impose in each case, allow services rendered by an officer to count for pension. So this is part of that. Namely, that although the three conditions are given, substantive and permanent we are concerned with, the proviso gives the power to the state that notwithstanding non-compliance with 1 and 2, you will still get pension if you want to give him.
Yeah.
And our notifications at page 55 and 57 indicate that if you have served and not confirmed, even then you will get pension. And the 2003 notification again has confirmed that this main thing, the root of the matter, as they say in the notification, is the service period, 20 years. If he has done, then there is no problem, you give them. So these are notifications traceable to this power.
This has been turned down in a division bench.
Maybe, Milord, I am not concerned with that at the
It must be
moment.
because this is relied on by the.
No, I'll immediately do, but I am setting the law, Milord.
Right.
Division bench will come. But if the three conditions are specified, then the proviso comes in, Milord.
So the power lies with the government.
Government. And that is a notification emanating from the government at two stages. One is in 96, the other is in 2003. And that relates to second requirement.
No, but these notifications.
Kindly have a look at it.
55.
55 and 57.
This is not under the proviso to Rule 31.
May not be, because they may not say it, but that doesn't mean that it will not be. Pensionary benefit to the government pensioners, family pension holders. This is 96. In the Government of Assam circular issued by memorandum dated 63, Department of Temporary Government employee who after a temporary government employee who retires after rendering temporary service of not less than 20 years under the government without being confirmed in any post is to be allowed the pensionary benefit as available to a retiring confirmed government employee either on attaining the age of superannuation or on being declared. I am not concerned with those three situations because that is also permissible. If you are dead, if you are medically invalid and certified, then also you are entitled. The Governor of Assam is now pleased to clarify that all temporary government employees who have retired from the service under the Governor of Assam fulfilling the criteria of not less than 20 years of continuous service will be eligible for pension from 1st September 1982 onwards. This is, however, subject to the condition that they satisfy all conditions other than the conditions of permanency against permanent post under the Government of Assam for usual pensioner benefit under Assam Services Rules 1959. So this is a notification which has to be read with or emanating from the proviso. which enables the governor, even though either or both conditions 1 and 2 above are not fulfilled. One is that condition, namely service under the government. 2, employment must be substantive and permanent. He will be entitled under this, and it is reiterated in 2003. They are making it absolutely clear.
That you'll have to address on this judgment also.
Yes.
Appeal.
Upendra.
No, the subsequent judgment. It is Ujjwala Nursery. Have you served the copy?
It is reiterated that the said OM clearly lays down that a government servant rendering 20 years of continuous service without being confirmed shall be eligible for pensionary benefit. In clearest possible term, again, it is explained. The focus is on 20 years of continuous service. After rendering 20 years of service, thank you. If the government servant is superannuated or so and so, those three conditions is not the root point. After rendering 20 years of service, if the government servant is superannuated or incapacitated or is dead, is not the root point. Any confusion in this regard is against the spirit of the OM referred to above. What more can be more clear from the standpoint of the government? They want to give pension because it is a property. Kindly see, they have served. They don't get a pension without giving that service of their life. And you have taken them fully, served them for 30 years. You have given them scale, you have given them increment, and all other benefits to make them look as if they are regular. After that, what is this rational reason that can deprive pension? Every government action has to be based on reason, Miller. That's Ramanna. It has to be a reasonable assessment. You are dealing with a government servant whom you have superannuated from government service by your letter, and he has served you for 20 years and more, but minimum period you served. And you have notified that yes, if they have served without even confirmation and permanence, they will get it. And they are reiterating in 2003. After all these notifications, they were referring to of 93 and all that, 149. Why will not, your lordship, it is established below the pension is a benefit to a retiring man. It is his property. It is not a bounty. An interpretation which will fulfill the object of such a provision is desirable to be given in favor of the servant, civil servant. Why, on what basis will not, they are saying about Uma Devi. The subsequent judgments, even that provision, that line will be available everywhere, that Uma Devi is not a shield for exploitation. Our rule itself says that even if you are, the second condition, you are not fulfilling, then also you can be given pension. There is no harm. And they have given two notifications. Why will the court not give effect to those?
All right.
Buzala Majari, okay.
We'll continue next week.
Okay. I'll also go through this. Hmm? Hmm? 22nd is Thursday, I am told you.
Second.
22nd of this month.
22nd.
Let us all introspect also, because some time is necessary for us.
Hearing remained inconclusive. Further hearing on 22nd. May.
Deep level.
Yes.
The time is almost over. May I pay for a date, madam, in the first week of June?
No. What is your grievance here?
But I'm challenging the order of suspension as well as non-payment of subsistence allowance. But from the affidavit now, what it appears that I have been superannuated in the meantime. So therefore, apart from setting aside the suspension, the pay, etc., that should be paid.
You have been superannuated in the meantime.
In the meantime, no disciplinary proceeding has been drawn up.
Is it under challenge here?
Suspension order is in challenge.
No, the subsequent order?
Subsequent, there is no order.
But you said you have been superannuated?
They have mentioned in the affidavit, that's all, without any order, without anything, my lord. Nothing.
Per
No
his
communication.
date of birth.
Huh?
Per his date of birth, he is superannuated even before he filed the report. He attained the age of superannuation before he filed the report.
When do you want it?
In the first week of June, my lord. If not inconvenient on 5th, my lord, 5th of June.
5th of June, okay. Let her be listed on 5th of June, as agreed to by the council to the parties.
Good.
You will pass orders next week with the presence of the council for the petitioner. Next week, the record you will be with the court master.
My lord, in item 52, my kindly date may be fixed.
If you take it from the court master.
Okay.
In item 41, some records were required to be brought. 41.
Yes, my lord.
Did you get the record?
Yes, Your Lordship, yes, we have received the instruction and the records.
You received the record. So we'll keep it on. Uh, or we'll have it on 22nd.
Can it be on 27th, my lord?
Why? Earlier date, then you take 20 if you want.
20 is, my lord, some difficulties are there.
Seven.
Problem.
Keep the records handy.
Yes.
And